My lord, we have filed a petition yesterday, my lord. There is an urgency there. So may I pray that will be taken up tomorrow?
My lord, supplementary 39, my lord. I filed my affidavit on Monday itself, my lord.
39.
39, my lord. So let it, but I'll call for the records, for let it be up at 2, my lord.
Okay.
And also, my lord,
At 2.
At 2, my lord. And also, my lord, item number 5, my lord. I will grab if it's taken at 2, my lord. Both items.
Huh?
At 2, my lord. Item number 5. Oblige.
Oblige.
May I pray for listing of a matter, my lord, for admission matter, my lord, settlement matter, my lord. Media in the next week.
May it please the lordship. My lord, similar player for listing, my lord. Next week, any day. Fine. Big gift.
I recommend some listing or admission matter, lordship. Final listen of fifth lordship.
May I please the lordship? Lordship, I am inserting item number 23, lordship. I am for the respondent, lordship. I have intimated that learned council of the petitioner, lordship. My lord, I am required to file a affidavit, lordship.
No. You're not filing. You don't want to file.
Lordship,
No time. I'm hearing it. I'm hearing it. You don't want to. We are not giving you time. We have given you enough time to file.
lordship, kindly be given short date.
No.
So that, lordship, we can file the.
No. I'm hearing it. I'm hearing it. Sorry.
Lordship.
You don't want to. You want to only waste time. They delay the matter by not filing affidavit. No. Yes.
My lord, this matter may come up in the next week for admission.
Lordship, with the concern of the other side, my lord, I'm back to mention item number 32, my lord.
32.
Yes, my lord.
Yes.
My lord, what has happened, my lord? In this case, my lord, we have been duly implemented, my lord. Respondent number 4, my lord, Assam Seeds Corporation, my lord. So we have sought for the instructions are awaited, my lord. So lordship will kindly give us some time. We'll file our affidavit in the meantime.
Who is for the petitioner?
I have taken the concern, my lord. I have informed the council for the petition.
Okay, right. Mr.
A.N. Sharma, my lord.
A. Sharma appearing for
Respondent number 4, my lord.
requirement number 4 is granted.
2 weeks, my lord.
2 weeks time to file affidavit in opposition. The stand of the respondents is that no approval has been given by the finance department before issuing the supply order. This is the matter of it.
My lord, a short prayer, my lord. Mr. S. Tamaya name may be reflected, my lord. He is the pending counsel for the
Okay, Mr. S. Tamare, Mr. S. This is the 2 weeks time is granted to Mr. S. Tamare, learned counsel for the point number 4, to file affidavit in the petition. Let me say this.
Lordship. I pray for listing in this repetition next week, my lordship. With admission.
As with others, but I beg to mention this item for listing of admission matter next week.
What is the matter about?
Contractual field, but pending since 6/1/2025. And date of filing is in 2021, matter.
May I please the lordship? But I beg to mention item number 25, my lord. This matter, my government is to file affidavit, my lord, in opposition, my lord. My lord, this matter. After 3 weeks, it is of.
Have you disposed of his appeal? Your basic case is that your appeal has not been disposed of.
No, my lord, transfer of consumers, my lord. During pending,
Correct, then you have filed an appeal.
yes, my lord,
Then-
appeal, my lord.
Has the appeal been
My
disposed
lord,
of?
appeal has been disposed of subsequently, my lord, after filing, my lord. And my lord, mainly, my lord, the grievance, my lord, transfer of consumers, my lord. Yes, my lord.
Right, Mr.
T shape, my lord.
T. Sheikh appears for the petition and submits that the petitioner's appeal has been disposed of, has been rejected,
Reject.
has been rejected.
But that was also silenced, my lord.
Sister. Mr. M. Chetia, learned counsel for the respondent, submits that affidavit will be filed within 2 weeks. This is the matter of 2 weeks. The
Hello.
matter pertains to transfer of the ration card holders
Yes, my lord.
from the petitioner's fair price shop to whose fair price shop?
But another.
To another person's fair price shop.
May it please your lordship. Lordship, I beg to mention item number 9 of today's list. Lordship, we have taken the consent from the other side. We need to obtain our instructions from respondent number 3 regarding this matter.
I thought pleadings were complete.
I also thought, but today in the morning, Mr. Gogoi said that they have instructed to file an affidavit on behalf of the corporation. Respondent number 3. Now,
Operation has not filed.
no, Lordship, we need to obtain our instructions.
Your case is what? That the bandage roll is not up to the
They're
mark.
drafted.
That's all. What are you going to say besides that? What are you going to say besides that?
I don't know, Lordship. Like, I'm not aware, but that's right. They might have something to say, that's right.
They might have.
They might have.
Mr.
M. here, Lordship.
Mbuya appearing
On behalf of Mr. B. Gogoi,
on behalf of Mr. B. Gogoi. Please for how much time?
2 weeks time, Lordship.
2 weeks time to file affidavit on behalf of the respondent number 3. Is the prayer of the prayer is allowed. The matter pertains to the stand of the respondent that the roll bandage, ROLL, roll bandage supplied by the petition was not of the required quality. Correct? List the matter after 3 weeks, 2 weeks.
Much good.
May I plead your lordship? I beg to mention item 16 for adjournment of my senior sample.
Yes, who is appearing for item 16?
Yeah.
Yes, so what is your stand?
In this matter, we are waiting. However, my lord, alternative remedy is available, my lord. They have not appealed before
What is
that.
the before
Commissioner, madam.
commission?
Deputy Commissioner cancellation.
Adjournment prayer has been made on behalf of the petitioner. On the other hand, Mr. J. Bokalier appearing for the
Respondent. For all the respondents.
respondent submits that. The respondents have not received any instructions. Till date. He submits that the petitioner, however, has an alternative remedy available in terms of, huh?
29 article order.
In terms of
29
Article Order 29
Yes.
of
PDS Assam Public Distribution Article Order.
of the PDS Assam
Public Distribution Article Order.
Assam
1982.
Public Distribution Order, comma. which year?
1982.
1982. Oh. Yes, madam. List the matter on Monday, comma, on which date the petitioner's counsel shall obtain instruction as to why it should not avail the alternative remedy available.
May I please, my lord? With the consent of the other side, I beg to mention item number 37 of today's list, my lord.
37, yes, what
37,
about it?
My lord, Paraguay's comments has been received from the department, my lord. I'm praying for some time to file our affidavit, my lord.
Who's for the petitioner?
I am.
Yeah, for the respondent number?
PWD, my lord.
Anyway, right, Mr.
H. Burwa,
H. Barwa appearing for
D. Gogoi, my lord.
B. Gogoi, standing counsel PWD. Submits that. Affidavit will be filed on behalf of the PWD
My lord.
within
2 weeks, my lord.
No, 2 weeks only. Here, madam, they have already taken twice time, madam. And the work has been progressing, madam.
Anyway, notice was issued only on 22/4.
Yes, madam.
No,
Madam,
22/4.
21/3, madam.
Huh?
Kindly see, madam. 21/3, while the matter was posted, madam. The motion is, madam.
Mr. Counsel, one thing I'll tell you. You need to give at least 1 month's time for issuing notice. 22/4 will end on 21/5.
No interim is there.
Today is what date?
No interim of that is
Maybe.
the problem. In fact, madam, on the private respondent, madam, justice service was also taken, madam.
Where is your affidavit of justice service?
Madam, I have already,
Where is the affidavit?
it's a file, madam. I don't know, that's on record or not, madam. But it is justice service.
We'll see. 9th day of April. When you arrived, Mr.
Page Burma, my lord.
Page Barwa appearing on behalf of Mr. B. Goyal and standing after PWD. Submit that instructions have been received. What?
Paravas comments have been received.
Submit that Paravas comments have been received. Accordingly, affidavit will be filed within 2 weeks. List the matter on, give a date. 15. It is also noticed that notice has been issued to the respondent number 5 on 22/4/2025 only. So, however, there is an affidavit of dusty notice on the respondent number 5 showing that notice has been served on 9/4. This is the matter on 15.
Value of this, my lord.
May I appeal, your lordship? Lordship, the order is at page 15, lordship.
Order page 15.
Page 15, 15, lordship, para 7.
Right. Heard Mr.
M. Das.
M. Das, learned counsel for the petitioner who submits that the petitioner have not been paid the admitted amount of rupees 4,11,153 in terms of the order dated 5/4/24 passed in WPC 2455 of 2023. Issue notice returnable in 4 weeks. Petitioner takes step within 3 days. This is the matter of the court.
Obliged.
May I please, your lordship?
Heard Mr.
Yes, yeah.
S. A. Ahmed. So if you notice, Mr. S. A. Ahmed, the counsel for the petitioner who submits that the vehicle hire charges of rupees 23,60,675 has not been paid. Issue notice returnable in 4 weeks. Mr. G. Bokalial accept notice on behalf of
For all that.
all the respondents. This is the matter of the 4 weeks to enable the respondent to file his affidavit.
Obliged.
This case also, I'm paying for notice, when the second time your lordship has set aside the order passed. And then now they are saying that 2015 order, which has been passed by them.
And that's been again upheld.
2015 order is because of the pendency of the criminal case. So that is not, that cannot be a ground for under cancellation of the license. What I pay, my lord, additionally, subject to your lordship and say for the 2025 reply says, RTA reply, that respondent number 5 has been allotted the license in place of the petition.
No, so let us see the order.
Your
Page 61.
So
they are
the
saying notice
impugned
not-
order is at page 61.
61.
Now,
Notice
it
could
says
not-
that,
notice could not be served.
they could not serve to
My
you.
lord, your lordship will kindly see, my lord, after the order passed by your lordship, I have requested, the petitioner has requested the supply of the verification report and other
Where?
inquiry report. That is at para 8 I have stated. Then I have given.
Para 8
reminder.
of which para? Para 8 of which
This petition, 2/7/24, petitioner requested for supply of field verification report. Then they have provided the field verification report. Then the 10 series, my lord. 10 series, my lord, that your lordship will get it, the reminder sent for giving the.
Yes.
the thing.
Why don't we fix a date for their
Yes.
appearance?
Yes.
That will clear, that
Yes.
will clear the
Yes,
entire
yeah.
matter.
My lord, maybe remember.
And now they are saying, your lordship will kindly say, they are saying 2015 cancellation order will sustain. 2015.
2015 order has already been set aside by
Set
this
aside by this
court.
court.
How can you revalidate it?
These officers, my lord, I
We'll
think
fix
they-
the date. Let the petitioner appear before the concerned officer better. Because that is the only issue.
My lord, concerned petitioner will appear before some officer.
Naturally,
My lord,
appear before the court of the additional district commissioner in the office of the additional district commissioner.
let it be to a higher officer. To the director.
Why?
Because he has been doing it for last 2, 3 orders he has passed, nothing has come much.
No, no, matter.
I think there is a lack of understanding of the matter. Your lordship will kindly see as per the provision of the act.
Let us see the earlier order that had been set aside.
First order, your lordship will kindly see, I'll just take your lordship, page 38.
Page 38.
Because there is a criminal case, his son died. And this was the issue because his son died. On the other hand, violated condition number 4, 2 and 8(2) of the license issued under so and so. On the other hand, as per report dated so and so, submitted by the official charge, a criminal case has been registered, white number so and so, against Sri Vishnu Dayal Sahu for the aforesaid offence, the license. Now your lordship will kindly see the rules. Order 15 months. This was set aside.
Page what?
The rule, order your lordship will kindly see.
Yes.
Order 15,
No,
1
no, why
and
should
2.
we go into all these issues? Why should we go into?
Yeah, but this was cancelled. This was set.
So
aside
this
for
already, this 10/11/2015 has been cancelled by this court.
Yes.
So now
And
the
this is
only,
page
the
42,
only thing is
43.
that in terms of the order passed by this court, show
Your
cause
lordship-
notice was to be issued to you, that's all.
No,
Right.
that is page
Heard
55,
Mr. P.D.
56.
Das, Learner Senior Counsel for the
Your
petitioner,
lordship also passed over.
assisted by Mr.
HR does.
H.R. Das. Also heard Mr. G. Bokalial for the,
All respond.
for the response.
No, no, except respond number 5. Is a private
For the respondents number 1 to 4.
1 to 4.
Who appears for 5?
It's private respond.
Private. No one appears for the respondent number 5. On considering the issue raised in this writ petition, this court is of the view that the writ petition can be disposed of at the motion stage itself. The petitioner is aggrieved with the impugned order dated 23/9/2024, issued by the Assistant Director, FPD and CA Biswanath, Office of the District Commissioner Biswanath. On the ground that the petitioner was not served any notice in terms of the order dated 27/6/2024, passed by this court in WPC number 3343 of 2024. Next paragraph. The petitioner hearing had approached this court earlier by WPC 3343 of 2024. Against order dated 26/4/2024, issued by the respondent number 4. By which the cancellation of the petitioner's PDS license has not had PDS license. Why? Cancellation order dated 10/11/2015 had not been interfered with. The petitioner's grievance was that the petitioner's grievance in WPC 3343 of 2024 was that the impugned that the order dated 26/4/2024 was cryptic and had not taken into consideration the issues raised by the petitioner. In his reply to the show cause notice dated 28/10/2022. Next paragraph. WPC 3343 of 2024 was disposed of by order dated 27/6/2024. By directing the respondent number 4 to issue a fresh show cause notice to the petition, along with the field verification report and any other inquiry report on the basis of which the petitioner's PDS license had been cancelled. So thereafter, the respondent number 4 was to pass a reasoned order. So consequently, the order dated 26/4/2024 issued by the respondent number 4 had been set aside in WPC 3343 of 2024. Next paragraph. The petitioner has approached this court again by way of the present petition, challenging the order dated 23/9/2024 issued by the respondent number 4, which has apparently been issued pursuant to the order dated 27/6/24 passed in WPC 3343 of 2024. Next paragraph. The petitioner's counsel submits that a perusal of the impugned order dated 23/9/24 would go to show that the cancellation of the petitioner's license by the earlier order dated 10/11/2025, earlier order/letter dated 10/11/2015, 10/11/2015, has been sustained only on the ground that the fresh show cause notice that was sent to the petitioner, could not be served upon the petitioner as the petitioner's door to the house was locked all the time. As such, it appeared that the petitioner had intentionally locked his door to avoid receiving any correspondence from the respondent number 4. Next paragraph. The petitioner's counsel submits that the petitioner was submit that the petitioner never intended to avoid receiving any communication from the respondent number 4. And in fact, the petitioner had submitted letter dated
Representation
submitted representation dated
12/7/24, 19/9/24.
12/7/24 and
19/9/24
19/9/24
and 15/10.
and 15/10/24,
And earlier 2/7.
requesting the authorities to
That was a reminder.
supply to the petitioner the field verification report and other reports, and another inquiry report,
Was given, my lord.
to enable the petitioner to make a proper reply
This was given. And then
He also submits that the said documents were given to the petitioner on
November 30/11/24,
in November and December 2024.
24% in RTI application.
December or November?
November.
In 30/11/2024. On 30/11/20, pursuant to an RTI application. And as such, the reason for stating that the petitioner whose house was always locked and the show cause notice could not have been served, could not be served in as reflected in the impugned order dated 23/9/2024 was a wrong statement made on facts. Still wrong statement. Listen, wrong statement on facts. Full stop. Next paragraph. On considering the fact that the impugned order dated 23/9/2024 had been made without hearing the petition on the ground due to the stand of the respondents that the petitioner could not be served the show cause notice in terms of the order dated 27/6/24 passed in WPC 3343 of 2024. This court is of the view that but what about the show cause notice? When will you give?
And also revived the order which was set aside by the court. By the impugned order.
Anyway. This court is of the view that afresh is of the view that the date of hearing with regard to the cancellation of the petitioner's PDS license should be made by this court, so that the petitioner is able to appear and give his side of the story, to enable him to give his side of the story. Accordingly, accordingly, with the consent of Mr. B.D. Das, the learned senior counsel for the petitioner, and Mr. G. Bokalial, the learned counsel for the respondents number 1 to 4. Which date? Give me a date.
May 15.
15 May 2025 is fixed as the date in which the petitioner shall be heard by the assistant director.
Director,
No.
director has done it twice, man.
How does it matter?
He will not give anything, my lord. Because this license has been allotted to respondent number 4 now, 5.
But what have we said in the order? We have said respondent number
It
4.
doesn't say because,
No, it has to be in compliance with the order. Order is
but twice, this is third petition before this court. And your lordship earlier, my lord, said, my lord,
okay. It should be. Then in that case, then it should be the director.
director, yeah. Let it be done. He's the
Director.
licensing authority.
My lord, in page 61.
Oh, is that assistant director? Let me a joint director.
One director is there. It is there. It is not. Okay. Assistant director, I think.
Let it be as per, my lord.
Yes, let it be as per that.
Let it be by DC, my lord, deputy.
District Commissioner, my lord.
Huh?
Let it be by deputy.
Why?
Because he's the district head.
Okay. So what have I said? But DC is not made a party here. highest bidder person shall be heard by the deputy commissioner, by the district commissioner Biswanath, district. With regard to, but then this order has been issued by the assistant director, no?
Assistant Director.
Huh?
Somebody,
By the assistant director, Mr.
Yes.
G. Bakalan.
Yes, man.
Let me, the assistant director, by the assistant director. At 10:30 AM, at 2 AM.
I was told on 15 election counting is.
Okay.
Something. Panchayat election, let it be on 28th.
Okay, 20,
20.
on 20, huh, 20.
20.
At 2 PM or at what, 10:30? At what time? What time?
What are 12 minutes, 12 noon.
At 12 PM. At 12 PM. At 12 noon, say 12 noon, not 12 noon.
They,
What about the share, they have, so everything is ready, you don't have need anything.
no, I don't.
Okay, right.
The impugned order has to be.
Consequently, the impugned order dated 23/9/2024 is set aside. It's set aside. The writ petitions accordingly disposed.
Only thing is that the license now, to the 25 reply has said, license has been given to respondent number 5.
Acha, you just said one thing, you just said one thing. It is also made clear that the assistant director shall also give an opportunity of hearing
My lord.
to the respondent number 5 at 12 PM, at 12 noon on 20/05/2025 prior to taking a decision on the issue. The decision should be taken by the concerned assistant director within a period of 1 week, from the date of hearing the petitioner and the respondent number 5.
1 week they may not do it, but let it be 2 weeks.
Okay, within 3 weeks. Within 3 weeks, huh? Deeply obliged. What is this? We don't need this. What is to be done here?
Lordship, similar matters are pending, Lordship.
Where?
Lordship and
Lordship, this is admitted amount and the covered case, Lordship.
Is it admitted? What is this?
Lordship, we need to offer instruction.
Page 14 is the liability statement.
Brahmaputra board. Hmm. When is, we'll dispose of all, I think, at one go. Correct. I heard Ms. K.K. Chowdhury, learn counsel for the petitioner, submits that the balance contractual dues of the petitions has not been paid, of the petition has not been paid. Issue notice returnable in 4 weeks. Ms.
M. Burman on behalf of Mrs. A. Gayan.
M. Burman on behalf of Ms. A. Gayan, accept notice on behalf of respondent numbers
1 and 2,
1 and 2.
Lordship.
Ms. D. Jane accepts notice on behalf of respondents number 4, 5, and 6.
3, 4, 5.
3, 4, 5, and 6. List the matter along with
WPC 1872, Lordship.
1872
Of 23.
of 2020.
Next one,
On which date?
It's on 2nd June.
On 2nd June.
That's it.
The petitioner developed very protector that the rigs since long it is doing the works. I have given a chart also to accept to since long, my lord, they are doing works successfully, my lord. Now in 21, my lord, 2 rigs were given to us, my lord, for 178 crore, my lord. Out of which, my lord, the 2 rigs, my lord, one is named as John 16, one is John 30. So far, John 30 is concerned, my lord, that has well performed and that it was released, my lord. So far, John 16 is concerned, my lord, it was given in a place where, my lord, the work was not done by them. So there was a delay, my lord.
Not work not done by them,
My lord,
work done by whom?
No, civil works. My lord, they have to do the civil works. Well, there are correspondences between them, my lord. Civil works are not done. And there was delay for both sides, my lord. And now for 161 days, they have deducted 5 crore 35 lakhs as a LD, my lord. So far,
LD, what is LD?
my lord, LD.
What is LD?
Liquidated away. They have deducted, my lord. We have not, my lord, we are not objecting to that, my lord. Now, what happened? They have given a site, my lord, where we have to do the work, which is J-band profile.
Huh?
J-band profile, my lord. They have to do all our, my lord, state, but this is a J-band. In J-band, my lord, what happened, my lord? The top drive, my lord, went malfunctioning. Top drive already. Well, after all, it's a machinery, my lord. So we could not, my lord, from that work. Ultimately, my lord, we had to place a new order to China. It is not available in India, my lord. So in China, my lord, for 6 crore 32 lakhs, my lord, we have placed an order in December 23. My lord, now what happened, my lord, on 1st of, well, if you also see at page 138, on 1st of July, my lord, they have given a mail to us, my lord. Page 138, my lord, bottom, your lord.
When did your rig when was it damaged?
Well, damage, my lord, in between the
When date when it was damaged? When did you intimate to the authorities that your rig was damaged?
well, no, it was working, my lord, by some way, but ultimately, my lord, it had so in the about October, my lord, it has been made, my lord.
Where have you said that when it was damaged?
My lord, I'm exact that, my lord, page 11, para 11, my lord, page 11. Well, second para. But then it will be here. The cause of action started around November 23 when the top drive of the rig, John 16, started to malfunction due to geographical conditions of the worksite and the site location and structure of the well. And accordingly, Mr. Bio also placed a purchase order to the Petroleum Equipment Manufacturing Company Limited, China, for supply of new top drive on 11/12/20. So immediately, my lord, we have.
So this is only by way of abundant caution.
Yes. My lord, necessarily, my lord, that because of the J-band, my lord, that could not function. And now, subsequently, my lord, what happened?
So the rig itself has not been damaged, only the top drive which has
Top
been
drive,
damaged.
top drive. And we have placed order for top drive for 6 crore 32 lakhs, my lord. That is also
Then
request.
so now
Now, on 138, my lord, your losses may come, my lord. They have issued a, my lord, bottom, my lord, because these mails are in the reverse, my lord. Page 138.
yes.
This is, my lord, issued on 1st of July. My lord, this is the second, my lord.
First of
Refers to
July.
subject matter, the last portion, my lord. We are providing headers so wherein committed to replace the defective TDS rig by the end of June so. You are requested to update the status of the TDS by today at 3:30 PM, as otherwise subject the contract right may be considered for termination as intimated earlier. So they were asked, well, we are asked to intimate them by 3:30 PM on the same day. Same day, my lord, we have intimated the earlier.
No, this letter is which day? This communication is of what date?
1st July. My lord, that is your lordship will get.
1st July 24.
Yes, 1st July 24.
Where is the date?
My lord, that middle portion, my lord, from Sudesh Vasumsari, sent Monday, July 1st, 24, 8/11. then that prior to that, my lord, another,
Now, you purchased the top drive when,
I put
23.
placed order, my lord, in December, but my lord, there was some holiday in the China and some parts were also, my lord, not available in China.
When was the holiday in China? When was the dates of holiday in China?
Dates, my lord, check dates are not there, my lord. But
How many,
there-
3 days holiday, 4 days holiday, or how?
well, and some parts were not available. Then, my lord, they have on 1st July, my lord, we have said on same day we have said send the mail, my lord. Your losses will see that mail. Dear sir, my lord, we have earlier mail. As per address mail, OM 20 so has been loaded from their workshop, shipped to port. Well, we have given the status. It has been shipped to port. We shall be sharing the shipping details shortly. Please be assured that we are making our best possible efforts to ensure delivery of the replacement of TDS as soon as possible. Request kindly to bear with us until then. So on that day, my lord, we have said that it has been already sent to the port, my lord. Now, ultimately, my lord, the risk, my lord, even Duliajan, next earlier page, my lord, your losses may come to page 137. The second mail, my lord. On 14 November 24, my lord, we have given this mail. If your losses see, it may please be noted that caption TDS has arrived at our yard at Duliajan. We now request you kindly to confirm the allocation of the well site for mobilizing our rig 16 with the new TDS and apprise us our readiness on the well
What is TDS?
top drive system, my lord. That is the, my lord, over the rig, it is there.
But then this, you see, that the site on which the rig is to be made, is to be put, has already been identified earlier.
My lord, identified, but that jail location, my lord, cannot be said, my lord, how it is to be done. That is underground, my lord. Underground. And that is why their malfunctioning started, my lord, there. Then subsequently,
When the site, when was the site handed over to you?
site was, my lord, said, my lord, yes. And just. Hmm? Page 84, my lord, till then, my lord, no work has been started.
No, whatever it is.
Yes. Till then, civil work, my lord, was done till now. 18 August,
Page.
page 89, my lord, 84. 84.
Yes.
Yes, my lord. This is, my lord, please find attach the document of for civil defense carried out at LOC, Rig Journal on 16/8/22. So the civil works were not done, my lord, by them. Subsequently, my lord, it was.
Look, I'm not asking you whether civil work done. I'm asking you when was the site handed over to you?
Yes, I. Then, my lord. Then at that time, my lord, 18/8/22.
Huh?
18/8/22.
18/8/22 site handed over.
And thereafter, my lord,
18/8/22 site
Yes.
was handed over.
yes,
When did you put the rig onto the site? That John, the rig number John 16.
my lord, then we have put it, my lord, there.
When?
But T223, my lord.
Huh?
T223, we have put it. T223.
T223.
10, page 10, 106 it is there. This is the work order issued on that day. And for the, my lord, some delay, my lord, they have already
Just a minute.
recorded.
You are directed, you are hereby ordered to commence the undernoted work
Yes.
on 3/2/23.
Yes.
So did you commence the work on
Yes,
3/2/23?
Yes, yes. We commence, we have done some work, my lord. Ultimately, my lord, when that this November, that thing happened, my lord. Till then, it was working.
where is your intimation to the authorities that your rig is not working?
Immediately, my lord, they were always supervising, my lord. They are going to give direction, my lord, to us. Huh? What? Then, my lord, they have issued a partial termination, my lord, 116. 116 partial termination was given. So they have directed us to replace the rig, my lord, at page 117, last para. Last para. And when we represented, my lord, they said that partial termination is withdrawn, but you have to pay the LD, 5 crore, 35 lakhs and what, my lord. That has been done. They have, so after LD, my lord, the reduction of LD, my lord, they have withdrawn the partial termination. In the meantime, on 7.
Who is JEL? You are JEL.
Yes, Jordan.
However, due to delay in mobilization on
Yes,
MS Gel's part,
yes.
the well was eventually spudded only on 3/2/23 after delay of 161 days. So according to this page 116,
Yes.
there was a delay on your part.
They say, my lord, but some
The
particular delay is there.
litigation was planned
but what
and
happened-
completed.
They have condoned this, my lord. In the meantime, on 17/7, my lord, they have issued another work order.
Due to poor condition of the drain pipe, this resulted in the further. The previous. Oil has incurred huge financial losses in higher well costs. Unbelievable. Partially terminate.
So now that has been condoned, my lord, by deducting the LD. That's the delay. What right?
Terminating the services of. So terminating the services of Rick John 16.
My lord, that was partial
On
termination,
60,
that was withdrawn. That was withdrawn, my lord.
No, partial termination will be with regard to the entire contract.
Yes, that,
Yes,
that,
But that termination of that one particular rig is done. Out of two rigs,
Yes.
one has been terminated.
yes, that was withdrawn, my lord.
Already terminated.
No, that was withdrawn.
Already terminated.
Then
Yes.
terminated by this page
That-
116 or terminated prior to this
Lordship, that may, page 130.
113. Yes, which part, which portion?
Last question. Before that, Lordship, page 116, whereby detailed reason was given, 116 also,
I'll just go to 116.
116.
My lord, this is a mail, my lord, by which we have advised to replace the TDS 16.3, the 130, page 130. The last para.
Hereby termination notice was issued. But since he has responded the same by later dated 18.
Just a minute, the termination. Termination on or not as per. As of terminate the contract.
Yes.
By giving 15 days notice.
Yes, sir.
Invited to the
Thereafter, Lordship, he responded, the petitioner has responded by later dated 18/3/2024. Page 119.
Just a minute, just a minute. If I then the terminal. TDS means again, TDS means?
Well, the top drive system. Top drive system. Okay, let me put it.
Yes, so this page 116 is a notice of termination.
Yes, that was a permit sale termination, my lord. That was withdrawn, my lord, later on by realizing the LD of 5 crore 35 lakhs.
Where is the withdrawal?
Yeah.
There is no withdrawal of this notice.
Lordship,
But
in considering his response, Lordship, by 129, page 129, by later dated 21/5/2024, again given some time, Lordship.
Within 21/5, with the okay,
Thereafter, Lordship, page 130.
30,
Page 130.
130.
130.
Yes.
Last portion.
last para. Hence, you are advised to replace the defective TDS which along with a
This is the
requisition of
final
another
terms.
faulty equipment of each so failing with a contact shall be partially terminated. That's this. So that is, so are they partial termination?
Hereafter,
Now, my lord,
no time is given.
now,
So this is final
what
part.
happened, my lord?
This is which date? Page 130?
130 page, 27 May 2024.
27 May 24.
Yes, sir. This is final termination, Lordship.
No,
That is not challenged.
No, that is not the, my lord. I have only shown 138 page, my lord. Thereafter, my lord, they have issued the mail.
Huh?
Thereafter, they issued the mail, 138.
138.
Yes. That's 17/24.
138, yes.
That your lordship has seen, my lord. 1st July 24, that you are requested to update the TDS today by before 3:30 PM. Otherwise, the contract may be considered for termination as included earlier. So it is, my lord, not terminated. And thereafter, immediate,
1724. Yes, Mr. He said this.
yes,
Lordship,
This page 138.
Thereafter, Lordship, he repeatedly, because time was given and thereafter he has not responded the same. That's
No,
why.
but this 138
Yes, sir.
has given him time again.
yes.
Time, Lordship, they say. When you have committed to 3:30 PM.
Yeah.
But that he responded, Lordship. Respond, Lordship, thereafter.
Same day we have responded.
Same day responded. As per so and so, the TES has been rendered from their works and skip to, we shall be sharing the skipping details shortly. Thereafter, he has forwarded several mails, but that oil has already constituted that the same is a termination.
No,
He is forwarding the mail, but he has not approached this honorable court from 2024. His termination was considered as a final termination. And already the so-called notice is also.
no, it is now, my lord, only. They have issued the termination now.
Where is the termination?
Yes, this is the, my lord, impugned order. 173, that is the, my lord, we have finished.
173.
Yes. Because although, my lord, they reached, my lord, liaison in November 24, they have not given me the work, my lord.
3:30.
Work
3:30.
Page, according to you, that page 138.
Yes, page 330, in 330. On
Until
that,
330.
yes.
Yes, 330 we have, before 330 we have.
And then lordship, just submission that week.
Let me say. Before 330 we have informed. Then, my lord, we are giving the details timeline. Then we said that in November, we has reached the deletion. Please give me the site. Now, page 173, my lord. This is the letter which is changed, my lord. Here. My lord, after 6 months, my lord, the reached, my lord, November. They have not. given
No,
the-
you see, page 173 is with regard to putting you on the holiday list.
No, that is, my lord, the notice.
It does not, it is not with regard to the termination of the.
Termination also.
No, no. It is only with regard to holiday list.
My lord, also, my lord. Yes, I'm just kidding. Please. My lord, that is your lordship fine, my lord, the termination is there. At page, my lord. Page 175. 175, my lord. Your lordship see. Where number? 13, where 13? So after that, my lord, 17 letter was issued to us, 17 mail. They have not said anything, man. They are. Really, my lord, formally, my lord, they have not. It is that. There is no formal order. And rather, my lord, in the meantime, on 17/7. Another.
You have not terminated him,
Yes.
Lordship, terminated.
no?
That is, they know the termination.
No.
Where is
Ali-
the termination order?
Lordship,
You see, you just come to page 140, this 175, 14.0. 14.0 says that the above failure on your part warrants initiation of action for putting you on holiday as per clause
Lordship,
44.5,
page 174.
172.
8.0.
Yes,
That in view of above default, a notice of termination was issued to you by letter number dated 16/3/2024. Already I have
where?
8.0. Lordship.
8.0,
Page 174.
173. Yes,
That in view of above default, a notice of termination was issued to you by letter dated 16/3/2024 as per GCC clause number 44.5 and 44.7 above, with a notice period of 15 days to replace the defective TDS of John 16 with a brand new one, failing which the instant contract would stand partially terminated forthwith without further notice. That you by letter number dated 18/2024, already I have pointed out, entirely requested all to revoke the termination notice citing multiple reasons and allow you time to till the end of April / May 2024 to provide a brand new TDS, purchase order copies enclosed by the, or provide a TDS from the company till the new TDS arrives for the interim period. While company was reviewing your request for allowing time to till end of April / May 2000, you again submitted letter reference number stated 14/5/2024, informing you about the status of the new TDS as per which additional time beyond 31/5/2000 will be required for arrival of the new TDS. That company by letter dated 21/5/2024, page 129. Lordship, I have already referred Lordship, granted you a period only till 31/5/2024 to bring and install the new TDS, failing which the contract shall stand partially terminated without any further notice. Moreover, it was also required by you to replace, rectify the other faulty equipment, IRD tabular within 31/5/2024. In the later, it was also mentioned that either after installation of the new TDS, along with the rectification of other faulty equipment, it will take another 3 months for allocation and preparation of the well plan for John 60. That by email dated 27/5/2000, you were again reminded that page 130 Lordship, about the above letter and to replace the defective TDS and all other faulty equipment of the rig within 31/5/2000 only, failing which the contract shall stand partially terminated with respect to John 60 without any further correspondence. Further, your request by letter dated 14/5/2004 allowing additional time beyond 31/5 was not accepted by while in the above email. That by later dated so-and-so 20/5, you again informed that the installation process of the TDS will take time and request time till end of June 2012. However, oil did not respond to your request since it was already informed that you had been granted time only till 31/5/2024. That since you failed to bring and install the new TDS to John so-and-so within the notice period of so-and-so, which was subsequently extended up to based on your comment and request, that the above failure on your part warrants in initiation of action for putting you holiday. So Lordship, after termination, the next consequences as per the contract Lordship. Lordship may peruse the contract, page 73. It starts from page 51.
Just let me see 129 first.
It is not that his contract was terminated in the 2022 or so, partially. After his request, that was revoked 2 times revoked. And therefore, 1/6.
So 31/5/24, it could partially terminate.
Yes, Lord. And thereafter, page 130 also.
Well, but the first of July mail is there. That has not been mentioned in this letter. 1st of July mail is not
But
mentioned.
because 1st of May, 1st of July was time given 3:30. And thereafter, he has,
Responded. I have responded, my lord. That is the main crux of the matter, my lord. Because on 1st of July, my lord, that had not been mentioned in the impugned letter. 1st of July, page 138. That is the mail, my lord.
replace the defect.
And in the meantime, my lord, they have
Page
given,
130. Lord.
given me another work order for 315 crore, my lord. On 17/7. That rig has been mobilized only on 1st of April.
So Lordship, page 130, and page 130, Learned Senior Friend is
Good
referring to
mark.
page 130, 138, Lordship.
They were not, my lord,
Lordship, page 138, 1 July 2024. It state about 3:30 PM on that day. That is not put under challenge, Lord. And thereafter, he has
we have mentioned at 11:42.
responded that he is unable by 3:30. Lordship. And after that, all the mail, Lordship,
But it is, as otherwise the subject contract so rig 16 may be considered for termination.
Yes, sir.
Yes.
May be considered for.
but
It is
thereafter-
may be considered for
But
termination.
thereafter, this mail, Lordship, subsequent, there is no mail, Lordship, from oil.
Okay,
Conservancy.
okay.
From
So,
page 137 also. It is on his part, Lordship, this mail is forwarded by him. There is no correspondence from Oil India Limited. Lordship. Because oil has already constituted that the same is a termination.
So up to 1st of July, my lord, they have not terminated.
page 130, if you have terminated it, if you have terminated his contract for that rig 16 in May, 1st of May, then how do you reconcile this page 138? Why did you send him another notice, another letter, communication?
Even thereafter granted time, Lordship.
So that means that there was no termination.
But subsequently he is unable to, he is failed, Lordship, and thereafter there was the earlier.
But then it
termination
says that
was-
if you, but then it says that unless you update, you give your update with regard to the TDS before 3:30, then the subject of rig 16 for termination will be considered.
Yes. But subsequently.
So where is
there-
the, where is,
sub-
just
subsequently-
a minute, Mr. Where is the consideration?
But subsequently, there is no commission from oil, which itself shows that there is a termination. And lordship, the petitioner has approached this, lordship, the petitioner has approached this honorable court by challenging the show cause notice. It is not his case that he has challenged the termination notice. It is case of the petitioner, he has challenged the show cause notice. And lordship,
Correct, because according to him, there is no termination order.
No termination.
already that page 130 itself shows that the termination is failing, which there is no consideration subsequently. And in the page,
What?
the 174 also, it says the terminated already. So even after termination, the consequences will be followed.
Where is the termination? That is the issue.
Lordship, then Lordship will fix the tomorrow, Lordship. I will place the documents, Lordship, because he has given time to 15 days time now.
No, my lord, but first question is this, my lord.
15 days time for what?
For so-called notice, for reply, Lordship.
Acha, show cause notice. Where is that page?
My lord, yes, but
Page 170.
well, that 15 days is given for the so cause, my lord.
Show cause notice.
Yes, but
Come no for suspension
but he
against.
has put under suspension for 3
Yes,
months. My lord. What happened? I checked with
Lordship
him.
will fix the
Well,
matter tomorrow, Lordship. I will place the.
Well,
No, you see, Mr. Counsel, how can you file a writ petition against the show cause notice?
Not so cause notice, my lord, suspension. I have been, my lord, your losses may see, my lord, I have given one, my lord, on 17/7, I have been given a work order for 315 crore. The rig has been, my lord, mobilized on 1/4, I have accepted that. Thereafter, my lord, what happened?
No, so this show cause notice,
Yes. Not so cause, my lord.
it show
I-
cause come notice for suspension against contract now.
Suspension, my lord, that is the question, my lord. Suspension means I have been suspended and my lord, because I have participated in the tender, giving, my lord, 6 crore 32 lakhs as EMD. My lord, and I was technically, my lord, qualified. My lord, now, what happened, my lord? By issuing the suspension order.
No, right now, the contract that you are having with them
Yes,
for the two rigs,
yes,
rig 30 and rig 16,
yes.
pertains to one contract. That's a different contract.
That-
Now you have been given a different contract,
The fund contract on 17/7/24.
17/7/24.
15 crore. That
So-
is another.
That is another.
That's the another. Then, my lord, we have participated in 2 tenders. In one, my lord, we have deposited 6 crore 32 lakhs as EMD.
No,
And
that
another-
you have deposited, that is
No,
a
no.
different thing.
There I have been successful in technical qualification, technically. Then another tender, my lord, we have deposited 74 lakhs and odd. Now your losses will see, after issuing the suspension, what they have done. My lord, your losses may see the page, my lord. The last page. My lord, page 177.
No, you tell me one thing.
Yes.
This is you are challenging a show cause notice.
Not so called suspension.
So,
Well,
cause.
Page 77.
It is a show cause come notice for suspension.
Suspension, my lord, 3 months I have been already blacklisted. My vendor code has been deleted. Locked.
Where is the blacklisting order?
176, my lord, your loss will fine. Last para. 176, last para. Order trial shall not come, my lord.
Further
But-
pending complaint, you are able to suspend for.
3 months from the date of issue of the
Which
property
cannot
notice
be-
to carry out the business for company participated in tender. But this is, and again, my lord, your loss is.
Yes, you said
This
this
is a
page, huh?
submission.
Next-
that
next
he-
step-
this
next
is
page
all
one-
submission the petitioner has already been
Yes,
already been blacklisted. It's
Well-
not because as per oil's banning policy, for issuing the blacklisting or putting a holiday list, the oil has to give opportunity of hearing
Correct.
apart from the issuance of the notice. This is the issuance of the so-called notice and
So according to
and-
his, so till a decision is taken by you, he can carry on.
yes, Lordship.
My lord,
So that is what
he
he's saying.
can carry
No,
out
well-
ongoing contact.
no, my lord,
He
your
can
loss
carry
will
out
see.
ongoing contact.
Your loss will see whether it is.
Lordship,
it is not.
peruse the
Let me argue. Page 177, your loss.
One?
One
Page
177.
177. Yes.
My lord, your same day, my lord, they, in the morning, my lord, they have said that your request to attend the pre-bid conference tomorrow against so and so, the link is meeting given below, my lord.
Where are you reading?
Well, page 177.
Okay, bottom.
Yes, what? Mails are, my lord, given.
You are requested to attend the pre-bid conference to tomorrow, 25/4/24,
Yes,
against or so. So this is a different contract.
Well, this is for different contract, my lord, then now next, the above, my lord, you'll also see.
Ah,
With reference to oil so-called notice come suspension, dated so and so, you are not permitted to attend the today's pre-bid conference, so and so. Already blacklisted, my lord.
No.
That is a suspension means blacklisted.
this is a different thing, yes.
This is 3 months.
I can understand, you see, I can understand suspension with
Yes.
regard to the
That-
existing contract,
Yes.
not to some other contract.
Yeah,
Oh, that's it.
another letter I have given, my lord, for 6 to 30 lakhs, that also that has been cancelled. You'll also see. That has been cancelled. That is the letter dated 29th of April. My lord,
Lordship, it is the pending policy of.
that as such, your bid against the tender. has
There's
been
nothing to consider.
Lordship, because pending policy is.
When is the, so you could not attend the pre-bid meeting?
My lord, then bid has been rejected, another 632, my lord. That 632 crore I have deposited, I was qualified in the,
Where you have called for the pre-bid meeting?
no,
No, this is different.
we have bid complete, technically qualified, then only price bid is to be opened. Then here, my lord, my bid has been cancelled, rejected. Well, this is, my lord, this is too much, my lord. This is blacklisting without giving, my lord, so-called. So that part, my lord, I agreed, my lord.
But,
And my vendor court should be-
but the interim order here,
Yes,
will only be till a decision is taken by the.
Lordship.
Yes,
Lordship,
yes, my lord.
Lordship,
Yes,
Lordship may allow me sometime.
sure, my lord. I'm only
Because
because
the petitioner is now harping that he was already blacklisted. If Lordship, the peruse the averments in the requisition.
No, I'm not going on that. I'm just going in, you come to page
176.
you come to page 177.
Yes.
176, my lord, that is last month.
Just a minute. You come to 177.
Yes, yes. And my vendor code has been blocked, it's 179.
Now you please read the bottom part. You are requested to attend. You got it?
Your reply of the above.
Yes, sir. You are requested to attend the pre-bid conference, page 177.
Yes, sir.
Have you read?
Yes, yes.
Through VC mode physical sensor on 25 against oil GM tender number dated sensor. Okay. Number 068. Okay. So this tender has got nothing to do with the present tender. Correct?
Yes.
Now you come to the top part of 177.
Yes.
177 top part says, with reference to our show cause come notice for suspension dated 24/4/2025. Where is this 24/4/25?
No, this is the last one, my lord, that's made.
Show me.
The second page.
Show me this 24/4/25.
Yes, that is the, my lord, impugned letter.
This is that page 173.
Yes.
You are not permitted to attend today's pre-bid conference against oil tender number 068. Same thing.
Because Lordship on 24, Lordship, it was forwarded, whereas the 24 also the impugned notice, the so-called notice comes, suspension was issued. And if the petitioner
That is what, how can you suspend him? That is the issue.
Lordship,
You can suspend him for that particular contract work maybe that he's doing. That 2 rigs, where the 2 rigs are.
Lordship,
But how can you suspend him for some other work?
Lordship may peruse our banning policy.
You're banning.
Yes, Lordship.
Where?
I have my.
Banning policy which page?
Any policy, my lord, that is the bet, my lord, that is the question, my lord. No. How they can do it, my lord.
Let us see the banning policy.
Lordship, I already,
This one.
2017. Because contract was 2021.
Yes, banning policy, yes.
Lordship, banning policy, the first page, Lordship,
Yes,
1.2.
yes.
While participating in the tender and performing under a contract order, the agencies are required to meet certain standard and integrity of the adherence in the terms and condition of the tender করে। In case of any agency fails to meet the standard benchmark of the entity, it is prudent to put the agency on holiday banning list for specific period in order to deter the agency from committing such default. Such decision shall be taken after following the laid down procedure. Since holiday listing or banning from business dealing involves civil
You see,
consequences.
Mr. Counsel, that is all right.
Lordship,
It's the civil consequence, all right.
so
But where does it say that till you take a decision to put him on a holiday list,
Yes.
you can suspend him? Where does it say that?
suspend provision, Lordship.
Yes.
4.1.4, Lordship.
4.1.3.
4.1.3, Lordship,
4.1.3.
subclause 3,
4.1.
1.3,
4.1.
page 6, Lordship.
Huh?
Page 6, internal page 6, Lordship.
4.
Below page number is given.
This is 4.13, not 4.1.3.
4.30, 4.30, subclause 3, Lordship.
Yes.
One thing. If action for banning putting on holiday list has commenced against an agency. Now 4.1.4, 4.40.
Just a minute. Action for suspension shall be initiated mainly in the following. Correct, but
Yes.
then you see, this suspension can only relate to the contract in question, which he has, it cannot relate to some other contract.
Lordship, effect of suspension, page 8, Lordship.
Page 8. Page 8. Okay.
One, an agency which you put on suspension list should not be considered for any ongoing
So-
future tender during the suspension. Any ongoing,
So is there a difference between putting someone on suspension and putting him on a suspension list?
pending, Lordship, in the departmental proceeding of also pending departmental royal, Lordship, one can, the incumbent can be suspended, Lordship.
Ah.
And in this case also, the putting on holiday listing, Lordship, is started from process for putting on agency on holiday list from 5.2, page 9. Five point zero, 5.1, Lordship,
So just a minute.
holiday list. And learned senior planner is submitting about a submission of EMD beach security. That is also provision is there, Lordship.
Just a minute. While communicating the suspension order, a show cause notice shall also be issued. Even the brief of the vendor of the plan. You see, you come to 4.1, 4.14.
Yes.
2. Page 7. While communicating the suspension order, a show cause notice shall also be issued to the agency, giving the brief reason for putting the vendor on suspension. The agent, why should not be put on the banning list for further business?
That is given, Lordship.
The CNP department shall process a proposal along with the show cause notice for putting the vendor for suspension.
Already suspended as well as the so cause notice issued, Lordship.
No, shall process a proposal along with the show cause notice for
Proposal,
putting.
Lordship, internal proposal.
Is the process.
And process for venue start from lordship 5.0. Holiday listing, putting on holiday listing.
The period of suspension shall be 3 months.
Yes, sir. Which can be extended for 1 month. One month. Limited to 5 months.
Have you got this?
No, well, that I have not got, but
Lordship,
because
that-
anyway,
that-
my lord,
that how-
that cannot be, my lord, for the, only for the
This is
contract,
as
my
per,
lord.
as per.
Here, my lord, the contract has not been terminated. Well, here the contract has not been terminated. Without terminating the contract, how they can do it, my lord? And moreover, my lord, here, that tender where, my lord, I have become successful in technical bid, that has been rejected now. That I have given the paper, my lord, after filing of this petition, my lord. Reason is given the same reason. Well, can it be done, my lord, by the oil, so arbitrary, my lord?
That.
Well, lord,
Lordship,
because,
petitioner has to
because, my
challenge the
lord,
said
in
condition.
that contract, my lord, at the behest of some other person, my lord, but it's been done. Because since November, my lord, we have said our TDS has reached, my lord, Duliajan, they have not acted anything, my lord. Till April, only when that contract, my lord, we became, my lord, successful in technical bid, then only this action has been started. My lord, this is the question, my lord. Absolutely malafide, my lord, at the behest of somebody else, man. This is what happens. Without terminating the contract, my lord, how they can do it, my lord?
That's why lordship by paying for the fixing of the matter tomorrow. Tomorrow.
Only this part, my lord.
Because already this communication was forwarded to him 29 lordship. And
No,
this,
no, anyway, right.
lordship
My
will
lord,
fix the
my
matter
lord,
tomorrow
in
lordship.
that case, my lord, is that letter, we have said, my lord, we have been given chance to submit our representation by 1st of May, my lord, in that rejection of.
You submit.
No, rejection, my lord, in that rejection.
Yes.
Because without this, my lord, the suspension part, my lord, I am not paying for the shock on notice. I am only paying for suspension part, my lord.
No, so this is a different issue. That is not
No,
the
this is,
issue.
my lord, that is what they are doing, my lord. For
That is not on the challenge
For
law.
suspension, they have rejected my bid, and they say that if you have anything to
Anyway,
submit.
Anyway, we'll take it up tomorrow again,
Yes.
but in the meantime, let me pass. Let me see.
Well,
Let us,
well, only thing, well, that the suspension part may be, well,
we'll take it up tomorrow.
Yes, sir.
Tomorrow, everything will be clarified tomorrow. But I don't know. Only thing is I've
Because
got,
logic
I've got, you give him a copy of this.
Yes, sir.
I want to read this. You please look at this. This
moreover,
point.
my lord, here, there is a judgment of the Supreme Court, my lord, because here till November, since November, my lord, they have not acted upon. They have not given me the work site, my lord, and they cannot blacklist me also, my lord.
No, I'm not on that. I'm not on that. I'm not on that issue. I'm only on the issue of whether there has been termination
Yes,
and
Yes.
whether there can be a suspension
yes.
prior to taking a decision with regard to putting you on the holiday list. Only that issue I'm going to take. I cannot go into those factual disputes.
Well.
Right. Heard Mr. G. N. Sahawana, that's the senior counsel. Assisted by Mr. M. Sahawana. Who submits that the petitioner was awarded the contract of hiring of 2 numbers of 2000 HP bracket minimum bracket close drilling rig package bracket with top drive for a period of 2 years in Assam and Arunachal Pradesh. The mobilization of one rig being rig number John
16.
30
30 was complete.
30 was completed on 8/7/2022. However, the mobilization of the second rig being rig number John 16 could not be completed on time. Further, when the site was handed over to the petitioner for mobilization of John rig for John 16, the top drive of rig John 16 started to malfunction. due to which started to malfunction sometime in November 2023. Is it?
Yes.
Comma, due to which the petitioner ordered supply of a new electrical top drive for John 16
Yes.
on 11/12/2023 from China. Yes, sir. Due to the delay in the arrival of the new electrical top drive for John 16, comma, the respondents have issued a show cause notice dated, well, page,
16 kilos, termination,
yes, their submission.
1/7.
Huh?
One twenty,
Show cause notice,
123.
come notice of suspension dated 24/4/25. Isn't it?
Yes.
Asking the petitioner to submit his reply to the same. Pending, further, comma, pending completion of the proceedings for putting the petitioner on the holiday list. The petitioner has been informed that he has been placed under suspension for a period of 3 months from the date of issuance of the show cause notice dated 24/4/2025. Next paragraph. The petitioner's counsel submits that there has been no termination of the contract between the petitioner and Oil India Limited pursuant to rig number 16, John 16, comma, while the contract was for the use of John 30 had been completed. Next paragraph. The petitioner's counsel submits that unless and until there is a termination of the contract of the use of John 16, the petitioner cannot be given a show cause notice for putting him on the holiday list and placing him under suspension. That's your case. He also submits that. Now, next paragraph, right? The petitioner's counsel submits that the petitioner has also been barred from participating in other contracts, besides his participation being barred in other contracts,
But tender has been rejected.
huh?
Tender has been rejected.
By rejecting his tender on the strength of the show cause notice dated 24/4/2025, which is in violation of the laws of blacklisting. That's correct?
But nowadays, my lord, the Supreme Court latest judgment say hearing we must.
Mr.
K. Kolita.
A. Kalita,
K. Kolita.
K. Kalita, Learned Counsel for Oil India Limited, submits that there has been termination of the petitioner's contract in relation to rig number John 16, as the petitioner had not been able to procure the top drive for John 16 within time. That is till 1/7/2024, comma, before 3:30 PM. He submits that as there has been a termination of the petitioner's contract regarding John 16, there was no infirmity with the issuance of the show cause notice dated 24/4/2025 and the placing of the petitioner under suspension for a period of 3 months till disposal of till the question of putting the petitioner on the holiday list / blacklisting was decided by by All India level.
But it will not affect his ongoing tender.
Yeah, that's strict.
And but the problem is, it is affecting his other tenders.
Not ongoing.
Already submitted, well, I'm successful in technical bits.
It's affecting his other tenders.
Rejection.
Gustav, in this respect,
And vendor code is also blocked.
just a minute, in this respect, he has relied upon clause 4.13 and 4.14 or 4.15 of the banning policy applied by the All India Limited, which is the guidelines for the action to be taken against erring and defaulting bidders / contractors, etc. Next para. The counsel for the IOCL also prays that the matter may be listed tomorrow. Stop.
All
Next
India.
para. Huh?
All India.
Oil India Limited. Next para. A perusal of the email issued by Oil India Limited on one 7/24 provides that the petitioner is to update the status of the top drive system for John 16 by 1/7/24 before 3:30 PM. Or else the contract in relation to John 16, inverted commas, may be considered for termination as intimated earlier, invert comma 2. This is at page 138 of the writ petition. And a simple reading, not complicated reading, a simple reading of the above prima facie shows that the IOCL has not, Oil India has not terminated the contract involving John 16. This is a matter tomorrow.
Hello.
No, why? Okay. See this. Mr. N. Burma, learned counsel for the applicant, prays that the Principal Secretary, Bodoland Territorial Council, Pokraja, PIN 783370, and the Superintending Engineer, Pokraja Road Circle, Kokraja, Assam, PIN 783370 should be treated as response number 8 and 9. Miss R.B. Bora, the counsel for the BTC, submits that she has got no objection to the application being allowed. Next paragraph. In view of the above, so and so are treated as response number 8 and 9. Petitioner should submit a corrected copy of the cost title to the registry within
1
1 week. Within 1 week. Within 1 week. Then I is accordingly allowed and disposed of.
Copy of the rectification, Sabon Aslam.
Huh?
Copy of the rectification.
Okay, next paragraph. In view of the order dated 30/4/2025, passed in IAC 1280 of 2025. So and so are implemented as response number 8 and 9. Issue notice to the response number 8 and 9. Ms. R.B. Bora accepts notice on behalf of the respondents, newly implemented respondents number 8 and 9. Petitioner to serve the corrected writ petition. Submit extra copies of the writ petition to Ms. R.B. Bora within 3 days. Huh? Okay, I'll say 1 week, 1 year also, you give it today, that I leave it entirely up to you. You have to do it right now also. Ms. R.B. Bora is granted 4 weeks time to file affidavit in the police. This is the matter of the police.
Here the petitioner is an IMF on licensing matter. Was otherwise running his shop, but due to restriction imposed by the Honorable Supreme Court, I was not allowed to run for a certain period. Madam. During the year 2017 and 18, I was not allowed to run. Madam. But when that restriction was withdrawn, madam, I was allowed to.
So it become instruction.
But only one thing, madam. For 17, 18, I could not run my liquor shop, madam. I have renewed my license, but for renewal, they impose the late fine also, madam. But that imposition is not permitted under the rules, madam, specific rules, madam.
This is rule also.
Huh?
Rule 130, madam.
Rule 130 of the Assam Excise Rule.
This is the only limited way, madam.
Show me.
I definitely required to pay the license fee, madam. But regarding the penalty part,
Page.
Page 134.
134.
Yes, Sir Lordship, Assam Excise Rules 2016. Rule 130. The licensee who fails to deposit the license renewal proposal as per Rule 129(1)(a) and Rule 129(2)(a) and sanction for renewal in whose favor has been delayed due to reasons attributable to licensee, and if for such reason licensee failed to deposit license renewal fee as approved in Rule 129 and Rule 129(2)(f), the license shall cease to effect.
Just a minute. I should notice. Thank you. No, so you were saying for 2017, 18,
17, 18.
you could not submit the,
Renewal proposal because I was not allowed to submit the renewal proposal.
because of the Supreme Court judgment.
Exactly, madam.
Ah.
So the reason for not renewal of my license is not attributable to me, madam.
Ah,
That is why, my lord, I need to pay the license fee, my lord.
so,
I am not denied, but penalty part is not.
But Lordship, where is the order where it says that that the renewal cannot be accepted? Your
This
Lordship?
is my specific step, paragraph 10, my lord. This is my
There
specific
is
step.
only a step, but there is no order from department saying that no, you cannot deposit license renewal fee or license fees or renewal fees now, as per the Supreme Court order.
but he has paid the, he has
he
paid
has-
the
he
the
has paid
subsequent license
Subsequent
fees. He has
license
paid.
he has paid.
Then let him pay then.
But what are the late fine is, Your Lordship?
How much is the late fine?
50% of the
50% license fee, my lord.
How much is the license fee?
2 lakhs, my lord. That time 2 lakhs, my lord. So 1 lakh is the penalty, my lord. This is my specific stand, paragraph 10, my lord. Paragraph 10 and 12, my lord. They are not denying it, my lord. By way of an affidavit, that statement has not been denied till date, my lord.
Paragraph 10.
10, my lord. Court and the petitioner was not allowed to renew his license for a year since his location of the shop did not conform to the distance criteria as specified by the Honorable Supreme Court. And subsequently, my lord, Paragraph 11
So
also.
let them take a decision. Let them take a decision. If you are unhappy, you come here.
Yes, that can be done. That can be done.
Whether they are supposed to pay penalty or let them take a decision. Why should we think that? Okay, if you're not happy, you come. Okay, right. Third, Mr. N.J. Khatane, Learned Counsel for the petition. And Mr. R.R. Gowai, Learned Counsel for the excise
Excise
department.
department, all the respondents.
The petitioner's counsel submits that the petitioner is having, no, the petitioner's case is that he's having an IMFL on license at Barigaon, Tamulpur within Baksa district, Commercial. Pursuant to the order of the Supreme Court on 15/12/2006. In the case of, what is the case name? Remember?
State of Tamil Nadu versus K. Balu, my lord.
State of Tamil Nadu versus K. Balu. Wherein it had directed that grant of licenses for sale of liquor along national and state highways should be stopped unless there was a distance of over 500 meters from the outer edge of the highway or a service lane to the said shop. Petitioner's case is that due to the above order, the liquor shop of the petitioner was closed since 1/4/2017. However, due to the relaxation of the direction passed by the Supreme Court and the ultimate withdrawal of the distance required for opening a wine shop in a municipality area, the petitioner was allowed to reopen his wine shop.
By order the 11/4/2018.
While order dated 11/4/2018, issued by
Issued by the Additional Commissioner of Excise.
the Additional Commissioner of Excise,
Assam.
Assam. Good stuff. Next panel. The petitioner's counsel submits that the petitioner has been paying his license fees for all the years till today, except for the period from 2017 to 2008. He submits that the petitioner could not apply for payment for renewal of his license for the year 2017-18 pursuant to the direction passed by the Supreme Court. And as such, the license fee was not paid by the petitioner. However, the petitioner, though willing to pay the license fee for the year 2017-18, as of now, there is a possibility of the petitioner being.
For 17/18, I have already paid and paid the penalty also, madam.
Acha, you have paid the penalty also. So you want the return of the money?
Exactly, madam, exactly.
Is that okay? So whatever, let's see. All the years. No, all the years, till date. However, as there was a delay in, however, the petitioner could not pay his license fee for the year 2017-18 on time. As he could not run his wine shop due to the decision of the direction of the Supreme Court passed on 15/12/2016.
And authority did not accept during that time.
And as the authority did not accept
Renewal.
the renewal fees thought to be paid by the petitioner. Full stop. However, on withdrawal of the restrictions by the Supreme Court and the state government and consequently by the state government with regard to the distance that a wine shop should be located vis-a-vis a national highway, national or state highway, comma. The petitioner was able to pay his license fee. Full stop. However, the license fee was paid along with the penalty for late fee in terms of rule 130 of the excise of the Assam excise rules
2016.
2016. Full stop. The next paragraph, the petitioner's counsel submits that as the late fee was paid by the petitioner due to no fault of the petitioner, but due to the directions passed by the Supreme Court, which had ultimately been withdrawn. Come on, the petitioner should not be made to suffer for no fault of it. Accordingly, he prays that a direction should be issued to the excise department to return to the petitioner the late fee that the petitioner was made to pay along with the license fee for the year 2017-8. Mr. R.R. Gogoi, the learned counsel for the excise department, submits that the petitioner can make a representation with regard to his claim for return of the late fee penalty submitted by him pursuant to Rule 130 of the Assam Excise Rules 2016, and a decision would be taken by the respondent number 2. Respondent number 2. Within a specified period. On considering the issue raised in this petition, this court finds that this court is of the view that the respondent number 2 should be no, is of the view that the petitioner should submit a representation to the authorities with regard to his grievance regarding return of the penalty paid by him. Which should be addressed to the respondent number 2. The respondent number 2 should thereafter take a decision on the same within a period of 1 month from the date of receipt of the petitioner's representation. The writ petition is accordingly disposed of. Public.
On the other side, what we to find is counter last notice.
Yes, I'm filing my petition during the course of that today.
Mr. Vinaya, the learned. Additional.
Standing Council, Assam State Age Compulsion.
Standing counsel for the
Assam State.
Assam State. Respondent number
Respondent number 3, 4, 5, and 6.
3, 4, 5, and 6 submits that will be filing affidavit in a position today. Accordingly, this matter after a week.
Will have to reply,
You have to file reply. How much time do you want? 3 weeks. Mr. Abhishek, the learned senior counsel for the petition submits that he will be filing affidavit in reply within 2 weeks. This is the matter of 2 weeks. 3 weeks. This is the matter of 3 weeks.
What is the? Apply.
This is the matter.
Matter on last topic on analytical court directed to list the matter along with the IA matter. But due to some defect, IA is not listed today, but I have already rectified that.
There's a mistake, okay. Okay, right. Mr. P.K. Mazumdar, learned counsel for the petitioner, submits that the defect in the application for improvement has been rectified. Accordingly, let this matter along with the application for improvement after a week.
Payment of the dues of the supplies we made. I'm asking for a simple order, let the authorities verify, and if they find it's correct, let them clear the dues.
I don't know, your supply order is for which year?
Lots of which year? Lots of various years actually to.
That is what, I don't know.
Yes, lots of it was the 15, right from 15, they have not paid us the bills. From the 15, 18, 16, it carries on.
2015, 16.
Yes, lots of it.
And then you have filed this in 2023.
No, lots of it was going on, they would pay, those commitments were there all the time. So let them verify lots, they're not disputing, let them verify and they find.
Where is the admission by them?
Lordship, the admission is there. And it should too.
What is to be done? So many matters. You want to file reply affidavit or what? Or should we dispose of?
Instruction,
Huh?
Lordship. We have received instruction.
Okay,
Instruction was received. But thing is that instruction doesn't say clearly about this admission of the HOD department also.
That's
They
the
say there is
problem.
no fund, they simple, they say.
Naturally, that's what you are doing. You are not answering the question.
But the executive engineer admits.
The department is not admitting.
But as per Tamsher Ali, that
That has,
it has to be by the head of the department, not by the.
the instruction is completely. silent.
Because that is also actually a concession given.
There is the concession, but he is the person on ground. He's the one who has.
But then you also have to file within time.
No, lots of this was going on. It's not that we have not filed. We were pursuing the matters over and over again.
Let me take a specific instruction, Lordship. Okay.
Or let them verify and pay, Lordship. That would close the matters.
What is the parawise comment say?
It says that they have placed the fund, but there is scarcity of fund here, Lordship. That's why I couldn't pay.
Okay, give us that. That means that will, okay, at least on that ground we can dispose of. Basically, you are admitting.
Basically, admitting.
But this is by the executive engineer. Executive engineer is of no use. In terms of Tamsher Ali, right? Third, Ms. M. Hazarika, senior counsel for the petitioner, assisted by Ms. S. Newar. Also heard Mr. R. Learned counsel for the
PhD department.
PhD department. Who else is there? Why haven't you made finance?
Finance a party, Lordship.
Finance is a party.
Respond number.
Oh, you are there.
Very much.
Why were you hiding somewhere? You are very important here. You are the most important. We have to haul you up.
Respond number 2.
Ms. R.M. Barwa appears for the respondent number 2. The petitioner's case wait, huh? This order dated 8/9/23, second paragraph. Okay. Next. Mr. Aragova, the learned counsel for the PhD, submits that Parawai's comments have been received by him through forwarding letter number PHEE/JOR/W-936/334 dated 21/5/24, issued by the Executive Engineer PHE Jorhat Division, Jorhat. He submits that in terms of the Parawai's reply received by him, which has been signed by the Executive Engineer PHE Jorhat Division, after submission of bills by the contractor, demands for fund were placed. The contractor received part payment against claim bills, and some parts of the same are yet to be paid, for which fund demand was placed several times earlier. However, the funds have not been received so as to settle the claim of the contractor. It has also been stated in the para-wise reply pertaining to para 9 of the writ petition that the statement shown in the petition is verified by the undersigned, and it revealed that the said bills are pending payment. For para 10, it has been stated that for the balance amount, liability statement has been sent and fund demand for settlement of the balance amounts has been made. It has also been stated that until and unless fund is received from the SPMU, who is the SPMU? Must be a scheme, I think.
Must be scheme.
But what is the SPMU?
He gave under the Government of India's Department of Drinking Water.
Huh?
Department of Drinking Water Supply.
Why don't you ask Uncle Google? What is SPMU?
EWSS is there.
State Project Management Unit.
Under the government of Assam?
It's a unit established within the state of government.
Under the state
State Project Management Unit.
management unit, bracket SPMU. Payment cannot be released. Next. Why are you not releasing the funds, madam? Do not keep quiet. Huh? Huh?
Instructions about.
Actually, what were you doing for the last 2 years? You were supposed to take instruction. Last 2 years, nothing has been done. You see, this parawise comments have been sent to them in in May last year. So that means the proposal was sent to you earlier to that. So there was enough time, right? Ms. R.M. Barwa, the learned counsel for the finance department, submits that he has not received any instructions till date with regard to why funds for release of the unpaid bills of the petitioner has not been paid. I have heard the learned counsel for the country. What is apparent from the parawise comments that have been furnished by the respondent authorities to their counsel is the fact that there is an admission that the petitioner is liable to be paid his bills, and that the same has not been done due to funds not being provided. Full stop. The petitioner having made to do certain works by the respondent authority, it was the duty of the respondent authorities to pay the petitioner his bills. And the issue of fund crunch could not have been, and then the issue of non-payment of his bills due to funds not being provided is arbitrary and unfair. Funds should have been earmarked prior to issuance of work orders to the petition. However, it appears that work orders have been issued to the petitioner without the state respondents having earmarked any funds for payment to the contract. Next paragraph. The above being said, perusal of the parawise reply given to Mr. R.R. Gogoi, Learned Counsel for the PhD, shows that there is no specific amount mentioned by the respondent that is payable to the petition. In view of the above, this court is of the view. Now, in view of the above, this court is of the view that the secretary, no, is of the view that the chief engineer, PHE, should verify the claim of the petitioner and take a decision as to the exact amount of bills payable to the petitioner. This direction has been made in line with the decision of the full court of this court, the full bench of this court, in the case of Shamsher Ali versus what? Union of India, what? State of Assam. State of Assam reported in 2008. 2008, GLP something, okay? Next, full stop. The respondent should thereafter make necessary funds available for payment of the admitted amount to the petition. The entire process should be completed within a period of 6 months from the date of receipt of a certified copy of the file. Read petitions accordingly disposed of.
Rest we are saying.
Huh?
Rest two are saying.
Rest two? There are two.
There are two more.
Okay.
That's it.
Okay, I've not mentioned any amount, no?
No.
Okay, but what about parawise comments? Is there
This comment we have received in 5213, but in 5214 we have not received.
5213 you have received, 512 you have received, and you have not received in
5214.
Only one.
5214 is not there. 5214 will make a slight change. There will not be anything. Acha, just put. The letter number will change, I think, in 5214. I think
Five, one, four.
I have to keep it.
Only 1/4 day.
What is this judgment?
No, these are similar, 3 months.
This letter number for letter number reference.
Okay. Okay.
Publish.
Yes, Mr. Bokalian. What is your affidavit?
This one number 4. File on 27/1. This one number 4, running page number 75. Start from 75.
Affidavit of
Delivered
respondent
is
number
7.
2.
This one number 4.
4.
4.
Okay.
77.
And who is 2?
2 is the commissioner.
Panchayat.
Yes.
So who has to release the money?
Actually, PNRT released the money to the deputy commissioner. And deputy commissioner released to the petitioner. And the deputy commissioner extended that the fund has not been released by the government. As and when the fund will be released, then they will release the amount to the petitioner. That is their step. And in fact, my lord, earlier
Acha,
occasion,
just a minute. You see, this post of commissioner in the office of Panchayat and Rural Development is different. He's not the,
no, different.
he's different. So it has to be done by the secretary.
Yes, by the government office. The last Panchayat election, my lord, they have done some work as per the direction of the deputy commissioner. And earlier, my lord, this petitioner was.
Okay, so they want the original vouchers, bills and vouchers.
Well, it is one hand, they have said in the affidavit, my lord. But the commissioner, but recently, my lord, I have gotten communication by your party application, where my lord, deputy commissioner clearly says that they have already sent the original vouchers and everything.
Why don't you file that in an affidavit?
Yes, well, then some time may be given, but I will file that.
Okay, Mr. R. Islam, learned counsel for the petitioner submits that he has received RTI reply
Yes,
to the effect that the original bills and vouchers with regard to the
Already.
claim made by the petitioner has already been sent to the PNRD
to
department
the PNR.
for release of the funds.
Yes.
Full stop. He submits that he needs a week's time, 2 weeks time.
1 week time.
He needs a week's time to file the same by way of an affidavit. Yes, who is appearing for the PNRD department? Yes, Data. We want to know why you're not releasing funds.
Similar matter is fixed on 29 before notice code. That is CS Enterprise pertaining to say contractual use. Matter will be taken up on 29.
No, why? Yes, Mr. Data. Why are you not releasing the funds?
My lord, the same similar matter was decided on that day also, 2-3 days back, my lord, where my lord, the authentication certificate was called from for the deputy commissioner. Same similar matter in the same list, this case.
He said that he has received a parawise reply from the DC's office saying
Not
that
parawise,
all the,
letter.
huh?
A letter sent. from-
Earlier, deputy commissioner, my lord, sent without validate certificate. Thereafter, this letter was issued.
31 December.
This was 31 December 2024, my lord,
Yes.
and this was 11/4/2025.
Take a photo,
Okay, then
photo.
the date may be given.
I can give him soft copy, my lord.
The date may be fixed, my lord, in the meantime. I will-
Yes, who is appearing for the DC? Have you submitted
No, my
the
lord,
original vouchers and bills in terms of that letter?
that instruction we don't have, however, our affidavit
Does not speak their respect money.
That is what we want to know. Whatever I said, whatever I said. A week's time, huh? A week's time. Next, Mr. G. Bokale shall obtain instruction with regard to whether the district commissioner's office has submitted the original bills and vouchers which have been validated by the competent authority. In terms of the letter dated
Well, 13/12/24.
13/12/24, issued by
The deputy district commissioner,
district commissioner.
Sir Chanvaram.
No, where is your letter? That
My note 11/4/2025.
11/4/25,
Yes, right.
issued by
By the commissioner, my lord.
the commissioner,
Panchayat and rural development.
Panchayat and Rural Development. Commissioner to the government of Assam.
No, my lord. It's
Okay.
commissioner, my lord.
No comment.
Directorate level.
This is the matter when?
2 weeks.
This is the matter of the two.
Date maybe.
After 3 weeks.
March. But that's not complete. 22nd. High level.
Affidavit is ready, madam.
Huh?
Affidavit is ready, madam. We'll proceed on 13th, I'll file it before it, because some officers are not there in this, there's some other engagement in Delhi.
13th of which date?
13th of this month, 13th of May.
13th of May.
13th of May.
Okay, right. Mr.
next
S.
week
Bora, learned counsel for the
BTC, madam.
BTC submits that affidavit is ready and will be filed within a week. This is the matter on 13th. On the prayer of Mr. S. Bora.
It's 17.
Don't issue, but the other side, they have filed the affidavit.
No, my lord, they have been taking time, my lord, will check because it was fixed on instructions, my lord, my instructions are here. Lordship, there is a specific query to the amount payable by the petitioner. It's a termination notice of 2022, they have challenged in 24. But will kindly come to order at the 13th fee.
So this is of 2024.
Yes. First for the termination was in 2022.
Huh?
In 2022, my lord. They preferred an appeal. Appeal was also rejected in 2023. They come to court in 2024.
So now this is this mining thing has been given to some other person. He's a party here.
Yes, my lord. Respondent 3. Or 8. 8. Not 8.
What was a complete earning?
So what do you want to show by this document?
My lord, kindly peruse the order dated, I think one order is the file. 13-3, my lord. My lord,
Yes.
pointed query was there, my lord.
Huh?
Amount of the parrot pairs, my lords, of the
Yes.
order dated.
So prior to signing the contract agreement,
Yes, my lord.
yes, how much?
That is the figure, my lord. Sir.
What is the figure? Prior to signing contract agreement, amount to pay this? Okay, it's around
Total amount to be paid was 15 lakhs, my lord. After that, to 5,26,000 I paid prior to signing of the contract.
how much did you pay?
5,26,000.
Correct. But according to this, you are supposed to pay.
Another about 9 lakhs something, 10 lakhs.
No, more than that. It comes to.
Minor debt.
Altogether, it comes to around 18 something. So that means you paid only 5 point something.
5% would be 1 lakhs, 146 lakhs was my tender bid. And now the person who was going to give me 44 lakhs only.
So 25% of 1 crore will be how much?
25 plus,
25. 25% of 1 crore is 25.
no, first I am to pay 5%.
Ah,
That's for the rules.
ah.
Then 15%.
Okay, so you have paid only, how much have you paid? You have paid only 5%.
5% I paid. Now, what happened here? In environment clearance was not given. Let him file a petition, I replied.
No, you tell me, there's nothing to decide.
No, there
You
is.
see, Mr. Counsel, when you are supposed to pay a certain amount of.
Get me the copy. What they have said in there.
No, according to the order passed by this court, you please read.
Yes.
You tell me that this order is wrong.
No,
I want to know, according to you, forget about their copy, forget about order of this court. According to you, your bid was 1 crore. Correct?
6 lakhs. Yes.
6 lakh. According to you, prior to signing a document.
Yes.
With the authority, how much money were you supposed to deposit?
As per rule 37, my lord.
Yes, how much?
First, the process of so-and-so. On the completion of bid process, the fall of hammer of the so-and-so. As the case may be, the highest bidder shall deposit an amount of 10% of the annual bid amount.
10% of the annual bid.
Yes.
Now 10% of the annual bid will be how much?
11 lakhs.
11 lakhs. Okay, forget about 11, make it 10 lakhs. Did you submit 10 lakhs?
No. There is a reason. That's why.
Reason, when you violated the statute,
My lord.
can you say that the statute can be violated?
My lord, because here unless the environment clearance comes from the government of India. You'll also only see.
When was the environment clearance given?
Yeah, it was finally given, it was 34 on 29/7/2022,
Yes,
34. And the termination preceded that.
let me see this 37.
But you will find that in page 267.
Yes.
Bottom, rule 37.
Yes.
No bid shall be regarded as successful unless accepted by the officer competent to census level. And the second shall be given. That will in advance, in advance.
Yes.
It does not say after environmental clearance is given. The process of for completion of the waste area payment shall be as follows. On completion of the bid process,
Yes.
that is the fall of the hammer or the opening of the seal bids, the highest bidder shall deposit amount equal to 10% of the annual bid as internal bid security before expiry of the bid amount.
Why there was delay, my lord, I have already explained in my revision as well as the with document, I have annexed.
Yes, what have you said? Let us see what have you annexed.
Last will kindly come. Annexure A is the letter of intent, B is the minor acceptance, C is mining plan. Rule 51, 52 mining plan has to be examined. Then my environment clearance. For environment clearance, the DA4 wrote to the central government on 12/1/2022, page 30. Date comes on 29/7/2022. In the meantime, my application for extension was submitted on 3/5/2022. That was murdered by the annexer E, page 31. The DA4 replies, gives a letter. 31 May of This is to acknowledge that the proposal has been successfully uploaded on the portal of the ministry. Proposal shall be examined in the ministry to ensure that required information has been submitted. An email will be sent seeking additional information, if any, within 20 working days. Once verified, an acceptance letter shall be issued to the project proponent. It was on 3rd of May 2022. Then again, I sent another matter. 530,000 I paid. Out of 15 lakhs was the first initial. Then matter system failed. I intimated that the payment system failed. Then my page 33. My application for extension was the time.
Look, when the statute provides that
No,
the
that is
thing,
true, matter.
huh?
That is true.
Then
But I have already, I have not reported. I have been praying for extension of time. Sometime 60 days.
no, Mr. Counsel, you see, when the statute provides that you should pay certain things in a certain manner and a certain period. Now, how can we say that the non-compliance of the same by you is okay? How can we condone it?
We are with you, I am satisfied. Then, my lord, I know environment clearance comes and environment impact assessment comes on 29/7/2022. My bid was rejected, my lord, on 6/6/2022. And an auction press notice was not published as per rule 34. This, in any case, what the settlement to R8 is illegal because it was not published, not verified, environment clearance was not obtained, and environment impact assessment got clearance of the government of India. So, without any pro moto, choosing a person gave me the bid. So, at best, my lord, if I do not get, it is a clear case for retender, my lord. How can a man be allowed to operate a mining, my lord, My bid was 1 lakh, 1 crore 6 lakhs. And he has given merely on 44 lakhs, more than half of the amount. That too, my lord, without following the rule 34. Lordship can come to rule 34. Public notice for inviting expression of interest. Bid open of
It's a newspaper publication, my lords. In a-
This is not trending. The people also list file immediately. And so
Interesting, lordship will come to page 23. When he accepts the letter of intent on his own volition, my lords, the bottom part.
yes,
Yes.
Mineral concession holder, bracket LOI holder shall prepare a mining plan along with the mining closure plan, including EIA duly approved by the authorized officer director on his behalf within 45 days of the issue of the LOI and ensure scientific. It is his own volition. He knows everything that I have to, he accepts this. Astopel goes against him, minus. He accepts this, he knows everything, and even in a letter which he seeks extension, in page 33, there is no whisper that I'm not able to get the mining SI clearance, CR clearance, so give me some time.
page 34 also lordship may see. Page
So this 90 days also he did not pay. He has not paid since then on.
And that about, well, interestingly, if we see the annexure L page 47, the settlement given to the private respondent, perhaps it is also expiring. It was 19/6/2023. It was for the period of 2 years.
2 years. Anyway, the period for which he has claimed is that's over. That's already over.
That is also over.
Because this is letter of intent is of 29/11/21 and the period of 2 years that ended in 23. So what remains?
23, he was given the settlement, final settlement of the R8 on 19/6/23.
No, Mr. Counsel, one thing,
So
Yeah.
it is the expiring matter on 18/6/2025.
huh?
They leads to the R8.
That is all right, but your claim for the mining area, for that mining period, has already expired. You see, on 9/6/21, the NIT was issued for a period of 2 years.
Yes.
So that June 21 expired in June 23. Now it is already May.
23 manner, if it is expired in June 23 manner, then there can be settlement to R8.
Oh.
That can be done only after the expiry of the. Tomorrow, in any case, this is now it will have to go to retendering, another tender. Yes,
Yes, it will go, but let this person complete it. It is, when did he finish?
Actually, the period would expire, Marot, if you also count from the date of giving allotment to the R8, then it will expire
it's
on
18
18.
Page 48, 19/3/25, it ended.
Yes.
It ended.
1948,
Page 48, 8 case matters.
8 case.
Date of case is 19/3. Last case.
So this is also, so this has become infructuous.
Yes.
So if it is infructuous, you you issue a fresh
Yes,
NIT.
yes,
that's
what
all.
I'm-
So we say we close it as infructuous then.
Yes, madam.
It's
we
okay.
have the expiry date, yeah.
No.
Yes, huh?
It is infructuous, madam, because he'll be
Infructuous.
inviting trouble because he's a defaulter.
Yes,
If we invoke the provisions, he won't be able to.
yes.
Whether I will
participate, madam.
participate or somebody else will participate, the
So
immediate.
only infructuous, madam, nothing.
I will only close it as infructuous. Then you
No,
can
no,
participate.
Only his submission, not my submission. On the basis of the expiry of the release period, it has been infructuous. That much they will also right.
Because I will have to write the entire thing if I'm going to do it in merit.
Yes, madam.
On merit, if I do, I will have to reflect all that has been reflected.
Either on his submission or my submission, because the release period is expired, we will.
That's all.
Yes,
On both of your instructions,
Yes.
on both of your consent,
yes.
I will make a submit, as I say, both of you have said that this be Writ petition has become infructuous. That's all.
We have the expiry list period.
Correct. If I have the lease period or with the respondent number here. Correct. I heard Mr. R.P. Sharma, learned senior counsel, assisted by Mr. S. Dhingia. Also heard Mr. D. Goyal, learned counsel for the respondent. The counsels for the parties submit that a fresh NIT would have to be issued for settlement of the Delhi River Stone Mining Area. Inverted commas A, capital A, bracket VB, bracket stone. In view of the fact that the settlement of the mining area with the respondent number 8 is to expire. Is to expire. Is to expire when?
No, the date of last case was 19/3/25.
But case is given before or after? Before,
Before.
then it is
Yes,
not
sir.
expired.
It is not expired.
It expire on 18th of June.
Is to expire on 18th of June
2025.
2025 as the schedule for depositing KISS. As the schedule for depositing the last KISS
Was 19/3.
was 19/3/2025. In view of the above, the counsels for the parties submit that the writ petition has become infructuous and the state respondent should issue a fresh NIT.
If so advised by us.
Issue a fresh NIT.
No, so advised because they are.
Correct. Issue a fresh NIT. If the respondent decide to.
Yes, by us.
If the respondent decide to.
Lease out the
To lease out the so and so, Delhi River for mining purposes.
Always.
The writ petition, in view of the real state above, in view of the consent of the parties, the writ petition is closed as infructuous. First up, the respondent shall accordingly take a decision as to whether they want to lease out the so and so for mining purposes after the expiry of the present period of settlement. And it will take action accordingly.
Always.
Always.
This is the matter with regard to electricity, my lord. A high tension wire is sought to be passed through my land, my property land, my lord. Yes, I made representation, page 15 may be seen, my lord. First, I made a representation on 9/5/2024 about the laying down of electric post without proper authority or authorization, my lord. No concern, nothing has been taken, my lord. No permission has been taken, no notice has been issued to me. Then when there is no response, my lord, I again send a representation. Then the lordship is page 16 may be seen, my lord. The landowners and the total land and that number I mentioned.
So what is the, so what does it violates, what does it violate?
63, but 68, my lord, of Electricity Act and Rule 313.
Let us see, let us see.
Yes.
Where is the provision?
License to.
Electricity Act.
Electricity Act, Rule 68, my lord.
Rule. Rule or
68.
section?
Section 60, sorry. Overhead lines, my lord. Overhead lines and a overhead line shall with prior approval of the associate government be installed or kept installed above ground in accordance with the provisions of section 2. The provision contained in subsection 1 shall not apply. Madam, so number 3, The appropriate government shall, while granting approval under subsection 1, impose such conditions, including condition as to the ownership and operation of the line as it appears to be necessary. Then number 4, the appropriate government may vary or revoke the approval at any time after the end of such period as may be.
How does it violate you? 68.
Yes.
How does?
My lord, you see the license, I've given that.
Yes.
Yes. Rule 3, my lord. 3(1)(b) may be seen first, my lord.
Yes.
B is fix any proposed overhead line or any stay or strut required for the purpose of securing position in a support or overhead line on any building or land, or having been so fixed may, after such support, provided that in case where the owner or occupier of the building or land raises objection in respect of works to be carried out under this rule, the licensee shall obtain permission in writing from the district magistrate or the commissioner of police or any other officers authorized by the state government in this behalf for carrying out the works. Then then 2, my lord. While making order, one sub district magistrate or the commissioner of police or the officer authorized as the case may be shall fix after consider of concerned person, if any, the amount of compensation or annual rent or both, which should be in opinion be paid by the licensee to the owner or occupier. Then
This is with regard to what?
with regard to laying down right, suppose my lord, my patta land, my lord, if they want to overhead
Just a
line.
minute. This rules may be called works of licenses rules. That means
Just obtain permission, that is important, my lord. No.
okay, yes.
The issue, section 68 perhaps would not be applicable in
Not
the instant
applicable.
case, my lords, because it only speaks to
That is
connection
nothing.
being
That,
offered
yes,
to one
yes.
single consumer. Now, here is a case where they are setting up a substation to cater to the electricity requirements of a township as well as nearby industrial areas. My lord will get that at page 18.
80.
18, 1/8 of the repetition, my lord.
Yes.
May I read this, my lord?
Uh.
With respect to the subject cited above, I would like to inform you that under AI so-and-so project, one new 33/11 kV 2x5 MVA distribution substation is being constructed at Borkusi inside upcoming Green Orchids Township by PKC so-and-so. As per the right of way arranged by the promoters of the so-and-so pole erecting for the incoming 33 kV lines from the 132 kV Azara GSS and outgoing 11 kV lines was carried out by the contractor. However, as soon as the above complaint was received, construction of the line was immediately stopped to meet the growing residential as well as commercial industrial electricity demands of the nearby area. Early commissioning of this vital substation is very much crucial, madam. So there is a substation being established. Now, the issue as to whether or not permission was taken, but that issue was addressed by the promoter itself. Now, they had obtained a right of way, which is the prescription under the electricity supply code, madam. May I just pass it the relevant provision? This is clause 4.3.2. When the consumer's premises has no frontage on a street and the service line from the licensee's mains has to go upon, over or under the adjoining premises of any other person, whether or not the adjoining premises be owned jointly by the consumer and such other person, the consumer shall arrange at his own effort and expenses for the necessary way leave, license or sanction. The licensee shall not arrange supply of power.
Who is the licensee?
Licensee is the APDCL, madam. And the consumer herein is the promoter. They have not even been made a party, my lords.
But line is going through my property, madam. And it can't be that somebody who was one fine morning would draw a line or over my plot. There has to be consent. I cannot object, but they have to take a consent and there has to be decision, my lord, of laying down the pipeline. They let them produce a decision, my lord. One fine morning they want to install a pipeline in or above my land, my lord. How that is possible? And there are judgments of this court also, my lord. I've given 2 judgments, my lord. But district magistrate is the authority, my lord, under the rules.
No, you see, one thing is that you will have to decide, the authorities will have to decide whether they're going to give compensation or not.
Yes. Now, as far as the demarcation issue is concerned, my lord, the APDCL has written to the circle officer. my lord. That is,
Those are issues, those are, you know, those are
perhaps-
issues that will be decided.
yes, my lord.
But the basic issue is, since they are the owners of the land, and since the line is going over their land, now the authority will decide whether they are entitled to rent or compensation. And or, in fact, whether the overhead line is going over the land at all. So those are issues. We will decide.
As far as the overhead lines are concerned, my lord, we were working under the bona fide belief that the promoters had obtained a right of way. That is reflected in our.
Well, they've come here,
They've-
they've come here.
But they are not party respondents in the present. proceeding.
So you give the name of the promoter, he'll
My lord,
treat
it's
them.
there, it's there, my lord, it's at page 18.
It is.
Where is it?
It's Green Orchid Township and the promoter's name is Messrs NK Power and Infrastructure Private Limited.
You make them parties,
I mean, but,
you make them parties.
but till then, my lord, they demarcate or they do it, my lord, they should not be, they should not progress the work, my lord.
Huh?
They should not carry out the work, my lord.
Why not? Whatever you are entitled to, you'll be paid. Where's the question?
My
Why should-
lord, this provision.
You'll be
lordship, they
Can
provide-
you, the issue is this, if an overhead line is going to go through the land,
Fine.
can you object?
No, I
there
cannot
are-
object.
If you cannot object, let it carry on, but then they will determine, the authorities will determine what is payable to you, what is not payable to you. And if they find that it is payable to you, you take it, and if you want to challenge it, you challenge it. Now, if you find that they say this, they say that, no, it's not going to go over there, your land, and you've got nothing to say, why should the
I am just
development be stopped?
I'm just reading the proviso, my lord, that provided, lordship may need to see that, my lord. Rule 3(1) B
Just
proviso,
a minute, proviso proof.
provided that in case where the owner or occupier of the building or land raises objection in respect of works to be carried out under this rule, the licensee shall obtain permission in writing from the district magistrate or the commissioner of police or any other officer authorized by the state government in this behalf for carrying out the work. So they have to give a decision.
Okay,
my lord.
provided, so
Your lordship,
they'll continue with the work provided they have this permission.
yes, my, yes, yes.
Hmm.
My
That are-
lordship will decide whether they have followed the rules at all, my lord. But this is a mandatory rules, my lord.
Okay, right. Heard Mr. J. Roy, Leonard, Senior Counsel for the petitioners, assisted by Mr. P.K. Munjal, who submits that 33/11 kV line is going to go over the lands of the, we're going to go over the lines of the land of the petitioner. Without following the provisions of the Works of Licensees Rules, 2006. Mr. J. Roy submit that no consent of the landowners / petitioners has been taken prior to the decision of the respondent authorities to lay overhead lines over the lands of the petitioner. He also submits that though the petitioners cannot object to the laying of the overhead lines, the licensee shall have to obtain written permission from the district magistrate or the commissioner of police for carrying out the works of laying the overhead line. Further, the district magistrate, commissioner of police or the authorized officer is to consider the representations of concerned persons, if any, with regard to the compensation and amount of annual rent that may be payable, by the licensee to the petitioner.
And also, Malco, there is no demarcation as being the page 18, my lord. The circle officer was to demarcate, but to our knowledge, there is no demarcation even.
So he also submits that there has been no demarcation made by the respondents as to the manner in which the lines are going to be laid over the lands of the petitioner. Overhead lines are going to be laid, huh, over the lines of the petition. Issue notice returnable in 4 weeks. Mr.
Each of them.
P. Chowdhury accepts notice on behalf of the
Respondents number 2, 3, and 4.
2, 3, and 4. He submits that the who is to be
NK, Green Orchid Township being developed by Messrs. NK Power and Infrastructure Private Limited.
he submits that
Number 3, man, serial number 3, or page 18.
he submits that PKC/MS NK Power and Infrastructure Private Limited, who is to construct the Borkuchi. No, to construct the Green Orchid Township has not been made a party. What else did you say? He also submits.
That's the right of way, the wayleave permission, that's clause
Ah,
4.3.2.
so what about it?
It is incumbent upon the consumer to obtain the right of way, my lords. And here, my lords, the consumer, which is the Orchid Green Township, my lord, they had obtained the permission. And based upon that wayleave permission, my lord, the.
He submits that the Orchid Green Township had obtained permission for laying the overhead lines from the concerned authority,
From the private respondent.
from the petitioner. In terms of
4.3.2.
regulation,
Yes, my lords.
regulation 4.3.2
Yes.
of the
AERC Electricity Supply Code, my lords.
AERC electricity supply. Issue notice returnable. I've already said issue notice returnable. No, I already said that. Who is for number 1?
That's the state.
Mr. G. Bokalel accept notice on behalf of fund number 1. What about
6?
156, sir? List the matter after 4 weeks to enable the response to file their affidavit.
Interior matter, they will not, my lord.
It is also made clear that if the district magistrate or the commissioner of police or any other officer authorized by the state government has not given permission in writing to lay the overhead lines, the same should not be. The works that have been initiated in pursuance to the same should not be continued till the next day.
Public. This is a contract, my lord. The lordship, one occasion lordship was, pleased to deal with the matter, my lord. They have raised, that, arbitration clause that we said that section under the arbitration clause, lordship may peruse, my lord, page 22, my lord.
You were given a contract work, correct?
Yes,
You did not complete. It was because it was terminated,
yes.
correct? Terminated when?
Terminated, my lord, page 107, my lord.
21/11, 21/11/2024.
107, 21/11,
21/11/24.
2024.
And there has been a subsequent tender issued for completion of the balance work.
Yes.
I have given that copy.
Which one is that?
17th of February.
17 February 25.
25.
And it has been awarded to whom?
No, my lord.
It has not been awarded.
It is not.
It's in the process.
Yes, yes,
What is the last date of submission?
my lord, they are in the next page.
Financial bid opening is on 4th April.
Yes, it was open, my lord, but due to some price.
Okay, so everything is complete except the final selection of
My-
payment. For the balance work,
For the balance. 91% of the work.
91% of the work
Yes.
has been completed.
No, only 9% has been completed.
Only 9%.
The actual work we have completed, my lord. Now only question of when the laying down the top of the road, my lord, then it was interfered, my lord. And the
You mean
extension was-
you mean the pavement work?
Yes, and extension was also granted, my lord, with after the expiry of date. Backdate extension has been given to me.
We don't know.
No, that I projected, my lord, that is the case. No, but initially, my lord,
No, let me see the habitation clause.
yes. Arbitration. Application. I want to show my lord what happened initially, my lord. Lordship may see page 22, my lord. Para 30 of my read petition, my lord.
Yes.
I have taken a plea, my lord, that it is stated that there is an arbitration clause available in condition number 70 of the general condition of contract. However, the same is not applicable in the instant case in view of the other parts in terms of the condition 54 of the general condition of contract. Further, the IP executed between the parties is also silent about the arbitration clause. The writ petitioner claimed leave of this honorable court to produce the general condition of contract at the time of hearing of the as well directed to do so. Then lordship. Then lordship may come to that impugned letter, my lord, termination, that page 107, my lord.
Yes.
Annexure 9, that is 21 November. Lordship may see para 3, my lord. Therefore, I am accepting officer of the contract on behalf of the government acting under the power.
107 or 100, which?
Page
107.
107, my lord.
Yes.
I'm showing that
Sorry,
condition
yes.
letter, my lord. That is the condition number 54, my lord. That is, so we said 54 doesn't. Now they filed their affidavit of opposition, my lord. They've said that clause has been deleted, my lord. Lordship may see, but first, my lord, page 47, para 30, my lord. 147. In their affidavit, my lord.
Page 147.
Page 147, my lord. They've taken a plea that has been deleted, my lord, para 30, my lord. I'm
Yeah,
reading one
yes.
paragraph above, my lord. Para 29.
Yes.
That with regard to the statement made in paragraph 29 of the petition, the answering deponent begs to state that the petitioner has an alternative remedy as per general condition of contract number 70 and 71, including amendment 1 to 48 being part of the contract agreement page 7287. The petitioner has a remedy to invoke the condition of arbitration and cancellation provided therein. Then para 30. That with regard to the statement made in paragraph 30 of the petition, the answering deponent begs to state that aforesaid petitioner can invoke condition 70-72 of general condition redressal of his grievance. Provision contained in subpara 3 of condition 70 of general condition of contract has been altered, deleted in toto and in amendment of number 46 of the general condition of contract. So they have said that condition 70 para 3 subpara 3 has been deleted, my lord. Now lordship may see page 256, my lord.
Yes.
256, my lord, then lordship may come 257. Your lordship, the amendment that is 46, that in between, my lord, condition 70 arbitration subpara 3 deleted the existing contents and shall have substituted black.
Where?
That page 257, my lord.
257, yes. Which serial number?
Serial number 46, my lord.
257.
Yes.
Serial number 47.
47, and then right side 26, serial number. Then it is, they said they're blank. It is deleted arbitration clause 70, my lord. Now.
Where? It says blank for blank.
Blank. That is that is deleted, my lord.
What has been deleted?
Yes, that is condition 70, my lord. I'm getting to condition, my lord. Condition 70, I'm getting it. Down, Lordship may see. Condition 70,
Sub-para 3 of condition 70.
yes.
Sub-para 3 of condition 70.
Lordship may come to page 300, my lord. Then arbitration clause 70 and 71,
Page 300.
300.
Yes.
This is arbitration clause, my lord.
Yeah.
Dispute between the parties to the contracts other than those for which the decision of the CWE or any other person is by contract expressed to be final and binding shall after written notice by either party to the contract to the other them to refer to the sole arbitration of a so-and-so engineering or equivalent having passed final examination of subdivision two of Institute Survey India the Government of India to be appointed by the authority mentioned in the tender document. Unless both the parties agree in the writing, such difference shall not take place until after the completion of the alleged completion of the works or termination or determination of contract under conditions 56, 55, 56, 57 thereof. Then clause 3, my lord, provided that all provided always the commencement or continuance of any arbitration proceeding hereunder or otherwise shall not any manner mitigate against the government right to recovery from the contractors also. Now, lordship may come to 71, my lord. There is a cancellation proceeding, my lord. That was 71, my lord, page 301. If dispute other than those which the decision of the CW or any person is by the contract expressed to be final and binding or any kind whatsoever arising between the parties to the contract during the examination of works or after completion or other determination, cancellation, termination of the contract, including any disagreement by either of the party action, inaction, opinion, instruction, certificate, or evaluation by the accepting officer or his nominee, the matter in dispute shall in first place be referred to dispute resolution board in case of contracts valuing rupees 10%. So it will go to dispute cancellation resolution board. Now, my lord, for that, my lord, I filed a reply that lordship will say page 335, my lord. Page 335. And I've also enclosed the
335. I don't have any 335.
but today I called it. Today it was called, my lord. Morning, early morning I called it.
Yes.
The page 335, para 16, I have dealt with it, my lord. Now, I've enclosed the new tender, my lord, the condition, my lord, extract of the condition, lordship may come to page 342. Arbitration where applicability of section 12 to so and so, my lord.
Where?
First of all, lordship may see page 345, my lord, cancellation, my lord.
Pages.
345, my lord, cancellation, my lord. Now, cancellation, my lord,
Yes.
as per the rules, my lord, the constitution of DRB shall be lost 36.2.1. Down below, my lord. The constitution of the DRB shall be a 3-member body as under chairman, member. This has to be declared at the time of contract itself, my lord, but there is no declaration, my lord. Then member, then lordship, clause 3.36.2.2, the next page, my lord. The name of chairman has a lordship.
Yes.
The name of chairman and members shall be notified by the accepting officer within 1 month of the date of acceptance of the contract. So now, I have no remedy, these people are never being appointed by chairman.
Okay, so 71 goes.
Goes.
There's 70 still left.
So we 70 that proviso, my lord. What is it? Yes. Lordship may see page 342, my lord.
Yeah,
Arbitration where applicability, clause 70, my lord. Arbitration where applicability of section 12(5) of the arbitration and cancellation has been waived off. Now.
where are you reading? Where are you reading? 342.
342 last line, my lord.
Last time. Okay,
Last line.
arbitration, yes.
Yes. Then 343. You have got-
Arbitration where applicability of section 12(5) has been made of, yes.
Yes. And then lordship may come to page 343, last common for all arbitration matter.
Yes.
This they were saying that deleted matter. Unless both the parties agree in writing, such reference shall not take place until after the completion or alleged completion of the works or termination or determination of the contract under conditions number 55, 56, and 57 hereof, provided in the event of abandonment of works or cancellation of the contract under condition 52, 53, 50. Now I'm 54, my lord. Hereof such inference shall not take place until alternative arrangements has been finalized by the government to get the works completed by or through any other contractor or contractor agency or agency. And they have said that this provision has been deleted now.
Which one?
This one, but
C.
provides so I've reading it.
C.
Yes, see, down below, provided that in the event of abandonment of the where my contract has been terminated under condition number 54.
Where does it say that this has been deleted?
They have themselves, they've said it, madam.
Where?
Their affidavit, madam.
Where? Where
That
does
is
it say?
para 29 and 30, my lord. Page number for 147.
It's only the provision contained in subpara 3 of condition 70 that has been deleted. It's only 3. 73 has been deleted, not the others.
They have filed 1 minute, I checked.
Now,
Leonard friend has to produce that, my lord, what has been deleted.
His case was, my lord, since one of the contract was terminated under the provision of conditions 54. Then, my lord, there was a provision in that earlier, my lord.
Condition.
Yes.
let us see the condition 54.
I think they have shown this only, my lord, while filing.
No, you see, when you look at there is in under clause 70,
Right.
there is no 1, 2, 3.
There is no 1, 2, 3.
There is no 1, 2,
No
3.
1, 2, 3.
So you are bound by 70. Where is the question of 73 or something not being applicable?
That is, they have projected their case, my lord.
That is
And they have shown also that page 257. Para 29, my lord, page 147.
147.
Now, these are the petitioner can invoke conditions of the provision contained in subpara 3 of condition 70 of general condition of contract IAF 2249 has been altered as deleted into the insert blank
Provision contained in subpara 3
3.
of condition 70. Subpara 3. Let us see what is subpara 3. Subpara 3 will be 1, 2, 3. 3 will be provided.
Provided.
Provided always at commencement or continuance of any arbitration proceeding, hereunder or otherwise shall not. So this only, this proviso has been cut, that's all.
I don't know whether this, that's what matter I said earlier.
Well, one thing is very
They have
clear.
produced this, but
You see, one thing is very clear, that the sub-para 1 has not been deleted.
because they have responded to our para 30, my lord, of the writ petition page 22. But now I got it, my lord. Arbitration, if your lordship see that this has been deleted, they have shown, my lord, this is the latest book, my.
And your termination of your contract is under section, under 54.
54, man.
So condition 54. So your case is that as soon as it is finalized, then you have to go to arbitration, not prior to that.
No.
That is your case.
Yes.
Lordship, I kindly take up my affidavit. But here, I have the original contract agreement also. It was signed by the petitioner. I have the endorsement.
No, you see, I want to know one thing.
Yes.
The termination of his contract
Yes.
was done under which provision? Under which condition?
Conditions 54.
If it's under 54,
Yes.
then okay, but okay. So condition 54 provides that. Okay. So this proviso has been gone, it's gone. So you cannot wait, you cannot say, you cannot take the stand that unless and until they have finalized the alternative arrangement, that then only you can go to arbitration. It doesn't say that. In fact, because if this proviso had continued, if it had not been deleted, then your case was all right. Then your case would have, then your stand that arbitration cannot be resorted to unless and until the final arrangements are made.
That
Was all right.
That has not been taken place. But secondly, my lord.
No, it's not required anymore. It's deleted.
But before that, my lord, I have to go approach DRB, my lord. Dispute
No,
Resolution Board. But where there, the officer has not.
Okay, no, but that we will take care. Because since it has to be done after within a month or after a month, within a month, within a month, it is not been done, 71 goes. So you go directly to arbitration. That's all.
But 70, my lordship may say, but my response to para 30, they have responded in para 30 again, my lord, they are replying. My plea at para 30, page 22 may be seen, my lord. Again.
Page?
Page 22, my lord. Writ petition.
Yes.
That it is stated that there is an arbitration clause available in condition number 70 of general condition of contract. However, the same is not applicable in the instant case in view of the order passed in terms of condition 54 of the general condition of contract. Further, the IP executed between the parties is also silent about the arbitration clause. The writ petitioner gave leave of this honorable court to produce the general condition of contract at the time of hearing and so and so.
Let us see 54. What does it say? Out here, this 54. Let me see what it says.
But that is cancellation page 291, right?
This cancellation of contract in part or in full one for contract is default.
Correct. So what is wrong? In part of so your contract was terminated because you could not complete within time.
Maybe.
Correct?
Mhm.
Actually.
Right.
It is within time.
But
As-
what they are taking the stand that the proviso has been deleted, that is not correct. Right?
Acha, you are saying that the proviso has not been deleted.
Not
That is it. Okay, that is it.
That has not been.
Okay.
Because
Yes, is the proviso deleted or not?
Yes, it has been deleted.
Show me that. Just only that. So that is the
Yes, my lord.
long and short of it.
Contract agreement, my lord, signed by the petitioners. Petitioner with the NES. You also may kindly have a look at this, my lord.
Okay, so
Just
no, you
yeah.
no, let him see it. He'll accept.
Yes, my lord. The
Yes,
signature
sir.
also there.
Ah,
That is there in the new condition of contract also.
No.
Which way?
please
But
look at
The
it.
document which is annexed, my lord.
You see,
Which way?
just look at 50, just look at 70. Take, condition 70.
This is. The signatures are there in the bottom.
No, again, he's showing the condition 70 application deleted.
Yeah.
But they are showing that provision has been deleted, my lord.
Correct. So you have signed
But-
it.
but-
Open eyes,
no, no.
open eyes.
Oh, I've signed it, but in the new contract, again, that clause is there, my lord.
But there is.
Where is the
a-
new contract agreement?
But I have given that in my reply, my lord.
No. Have you signed the new contract agreement?
No, you contracted by the other party, but
Sorry.
this is.
Sorry. If your contract happens for another 100 years, then what will happen? There'll be maybe 200 other contract agreement. And unless you sign it, you're
Well,
not bound by it.
My lord, is not clear about from them, that condition arbitration subpara 3. What subpara 3 he means to that,
Yes,
so
no,
he
that-
can only say.
That I will show, my lord.
Sure.
Yes, kindly take up my affidavit.
Yes.
But that, the part which is, my lord, which is deleted is not a part of this affidavit, because, my lord, we have annexed the up-to-date general condition of contracts. So here, my lord, that part is not there. It was his case.
After the contract,
In para 30, he says, my lord, for that particular sub-para, my lord, he could not invoke the arbitration.
Arbitration clause.
Yes. That
Because
was his
of
case,
that-
not our case.
But according to you, that has been deleted.
Yes.
And no, I am not going to go into your submission. I am going to go into what you have signed in your contract agreement. That's all. Just show me that.
Yes.
We cannot go into what might have been, might not have been. We just go into whether you are bound by.
but what they have deleted, that is not before the court, my lord. That is.
No,
why saying-
I will see
No.
if it is deleted here, then it's deleted. Finish.
No, but he has to show matter what provision has been deleted, my lord.
No, we will see whether the portion that you are relying upon.
Right.
To hold that a reference to arbitration cannot be made, whether it is here. That's all. Where is it?
Which
Where
one,
is the contract agreement?
which one, my lord?
That is they are not showing.
That condition 70,
Yes.
the proviso, the absence, where is it? I thought,
That didn't form part of this, my lord, contract agreement. That's why it's not there. In the affidavit, my lord, I have annexed the up-to-date, my lord, general condition of contracts. When, my lord, my senior fellow has taken a lordship too, lordship has read that. That particular subpara is not there now, my lord. When the agreement was signed with him, my lord, that subpara was not there.
okay, sub-para,
Yes, 3.
arbitrate sub-para 3 deleted and existing
Yeah.
content shall substitute as well.
Yeah. It's not there.
They have to show that they are in arbitration clause, that is there, my lord.
What?
They have not shown that's the one word
No,
that
no, no,
deleted,
no,
but
no,
what
no.
is deleted?
No. Wait.
In IP, there is no arbitration clause, my lord.
He is an integrated person.
Yes.
It's just for integrated.
Amendment to general conditions of contract. Okay. Right. You go for arbitration. Right. So just tell me the facts of the case. When you had participated in pursuant to NIT dated
My lord, 28/2/2022, my lord.
28/2/22. You were the lowest bidder.
I was the lowest bidder.
Lowest bidder and agreement
I accepted the tender matter on 28/2/2022.
28/2/22 accepted tender.
Integrity Pact Agreement I signed on 2021/22, my lord.
IPA signed on
It's about page 30, my lord, but only the date is not there, my lord, but 2021/22. But work order issued to be, my lord, on 29/3/2020.
work was to be completed when?
It was to be completed 18 months, my lord.
3rd September 2023, 3rd October, sorry,
3rd October.
2023.
Not completed, so terminated in 11 November. November 24.
Yes.
Then extension was granted, my lordship. See the one with the extension, man, 14/7/2000.
No, you see, I'm not going into those aspects, whether you're correct or they're correct. That let the arbitrator decide. Why should we go into this? These are all technical matters. These are all technical issues.
I go for arbitration, this is something, but there is no DRB, proper DRB as per the terms of the contract.
DRB, we will clarify that because
Yes.
it was not constituted in terms of the provisions, they could not go, and accordingly that there is no requirement of going there.
Independent person, my lord, not from their people, my lord.
That has to be there. It has to be, no, but then, yes, for railway it is different, I think.
Here also, Manoj, I think we have
They
our
can't-
own panel of arbitrators,
No, that-
Ministry of Defense. Manoj.
That is been negated, my lord.
With arbitrator will have to be independent person.
Independent person.
I think 12/5, what is that schedule? 12/5. 12/5 and the schedule, no? I think they will have to say that they are impartial or having no interest. Saying that issue independent, yes. But I think it's separate, it's different from the railways, I think. Railway is slightly different. So,
This is Ministry of Defense.
so we take an arbitrator from where? But this is all technical issues. Huh?
Lordship will just observe it, my lord, then we'll file an application for appointment arbitrator under section 11.
Huh?
But we have our own panel of arbitrators, Manoj, appointed by the
That
Ministry
cannot
of Defense, because they are Manoj, the technical persons, the experts. The child engineer, chief engineer, like that.
What does the provision say? What does the arbitration provision say? Sole arbitration of an serving officer. Cannot be serving officer. Has to be an independent person.
Has to be independent person, that is, there is no doubt about it.
Okay, Mr. Adhikari.
My lord.
Cannot be a serving officer.
Only lordship will record that observation that we have realized that, my lord, that we asked for approval that was not given in time. 8 months, my lord, 18 months contract. After 9 months, the approval is being granted, my lord. They're sitting over.
Okay, but then they gave you more than one year's time
Yes.
extra.
But there are lots of factors.
I
my
can
lord.
understand if you can say that, factors will be there both sides.
Then extension was granted, that to also retrospective effect, my lord, can be extensively granted.
My lord, 4th of April, the
Of course,
work.
that all.
Ended about training,
Take
the
the
site
period
was ended about training, my lord.
Okay, right.
We had to complete. the
Okay,
first
right.
period.
No, going to do. Third, Mr. There are Learned Senior Counsel, assisted by Mr. Huh? R. For the petition. Also had Mr. M.R. Adhikari, learned CGC for the responsible. The petitioner is aggrieved with the order dated 21. Is it order or letter? With the letter date, termination letter dated 21/11/2024. terminating the contract What contract was it?
The road construction, my lord.
A road construction contract with the petitioner. On the ground that. On what ground? No, no, this is under condition 54
Yes.
of the general conditions of
Oh,
contract.
Page 107 will be quoted, my lord.
Huh?
107 very small letter, my lord. That may be quoted. 107. In this petition, my lord, he had challenged the validity of that.
As he has failed to complete the contract by the due date. The impugned termination letter also stated that the work should be completed through another agency. And the performance security and retention money up to the last paid RAR would be forfeited. Full stop. In addition, all the tools and plants and materials lying at the site would be confiscated by the government. And no compensation would be given to the petitioner. Also, the petitioner firm would be debarred from participating in the tender for the balance work in the above contract. Full stop. Next paragraph. The petitioner's counsel submits. No, full stop. The petitioner's counsel submits that the petitioner's contract work having been terminated under condition number 54 of the GCC. The petitioner cannot apply the arbitration clause provided in clause 70 of the GCC. Inasmuch as, an alternative arrangement has not been finalized by the respondent to get the balance work completed through any other contractor or agency. He submits that the same is provided in the proviso. In the first proviso to condition to clause 70 of the GCC.
Sorry to interrupt, my lord, but that one particular, my lord, general condition of contract is not part of this contract, my lord.
That is his submission.
Yes,
But he can say anything. He can say that what aloo tikka is mutton tikka also. How does it matter? What have I said? That is the third subpara of clause 70 of the GCC. Next paragraph. Mr. M.R. Adhikari, the learned counsel, the learned CGC, on the other hand, submit that the first proviso to clause 70 of the GCC, which is the third sub-para of clause 70 of the GCC, has been deleted
By amendment number 46.
by amendment number 46 as reflected in the
Amendment to the
amended general conditions of contract, which has been signed by the petitioner and the respondent. He submits that as the petitioners have signed the contract agreement with the deleted first proviso / third sub-para of clause 70 of the GCC, the petitioner cannot press for. The petitioner cannot now take a stand that the first proviso / third sub-para of clause 70 of the GCC is applicable to his case. I have heard the learned counsels for the parties. The dispute raised by the petitioner and the respondent is basically a factual dispute. In as much as the question to be decided is whether the conditions of the contract agreement signed between the parties contains the first proviso / third sub-para of clause 70 of the GCC. Next para. The original contract agreement signed by the petitioner and the respondents have been produced today. And a perusal of the same shows that the first proviso / third sub-para to clause 70 of the GCC is not a part of the contract agreement, as the same has been deleted. The relevant portion of the contract agreement is reproduced here below as follows. The 6, you can see this one, right? There's no page number. It is a part of this. This pink. 4626 is written. Next para. Clause 70 and 71 of the GCC provide as follows. This is, you take it out from here. Page, I think you can take it from here also. Take it from here. Page, no, wait, a page, not here. Take it from here. Page, no, it's here, it's here. You can take it from page 300
Yes.
and 301. Okay. 70th century. Okay, where is the provision that the time period for making, for constituting the constituting the DRB?
That is my reply.
Okay, the reply,
Reply. Or should we see page 346?
Next, correct.
page 345, 346.
No, next, right? The affidavit in reply submitted by the petitioner on 28/4/2025 has annexed
Extracts of new tender.
extracts of the
These are special conditional contracts
Special-
that should also be found in the record.
extracts of what?
Special conditions of contract.
Special conditions of-
Extract of the special conditions of contract.
Hmm.
Wherein it has been provided that the constitution, uh, dispute resolution board, bracket DRB, shall consist of 3 members, which should be notified by the respondents within 1 month from the date of acceptance of the contract. In the present case, no DRB has been constituted even till today. Okay. In view of the above, it is clear that there is no question of referring the issue raised by the petitioner with regard to the termination of his contract before the DRB in pursuance to clause 71 of the GCC. In view of the fact that there is a specific arbitration clause provided under clause 70 of the GCC, sans the first proviso / third sub para of clause 70 of the GCC, comma. This court is of the view that the petitioner can approach the respondent for reference of the dispute between the parties to arbitration even prior to finalization of an alternative contractor slash agency for completing the balance amount of work. For completing the uncompleted balance amount of work. Next para. Next para. Yeah. However, keeping in view the decision of the Supreme Court in the case of Dash versus Dash, this court is of the view that the reference to arbitration under the Arbitration and Conciliation Act 1996 would have to be done before a independent arbitrator who does not have any interest. Give me the Arbitration Act. independent arbitrator who does not fall under any of the categories specified in the 7th schedule of the Arbitration and Conciliation Act 1999.
The demand being made by.
Naturally, that'll have to be made by him. In view of there being an arbitration clause in the contract agreement, the petitioner, the present writ petition is dismissed with liberty being given to the petition to avail of the alternative remedy by invoking the provisions of
This is.
clause 70 of the GCC as executed by him for redressal of his grievance. The writ petition is accordingly dismissed. One thing you write, huh? The counsel for the respondent submits that the petitioner's contract work was terminated as the petitioner could not complete his work in time, and as the petitioner had completed only 9% of the work, even with all the extensions given to the petition.
I observation also my lord that it was contract was retroactive effect, my lord, they tried to give extension of time, my lord, which is not permissible under the law.
How that?
Which is not permissible under the law, my lord.
Why?
Because retrospective effect, lordship.
How do we know about retrospective?
No, that is
That is-
letter speaks itself, my lord.
That is yes, sir. This is 9% is not denied.
No,
Why?
we denied, my lord. Lordship,
Okay, according to you, how much have you completed?
I think with the 30% so we.
Okay, just say the petitioner submits that his petitioner has completed 30% of the work, even after the extensions were given to him.
We have taken the counter that one at a time.
Anyway, that I
At
just.
that time, he has not deployed more than 5 to 6 levels, 1 JCB and 2 tippers only. So how can you complete one?
I know, even in Mizoram, we're having same problem.
With army, it's very difficult to work, my lord.
And some of the contractors, they are from here.
Yes.
And they're using limestone rocks for the stones there. Limestone rocks are very bad. There's no use. After a few months, a few weeks, it'll all be cracked. Anyway. We'll return this later, huh? This also. This we can give it straight away. This we can give it straight away. No. This we just take a photo of that.
Online.
Apply, sir.
18 only. Oh.
Lordship, I'm entitled to get some contractual amount of hire charge of a vehicle, Lordship. Lordship must order RDR on But in this matter, we have yesterday filed an additional affidavit. So that is probably not on the record.
So have you been given any money?
Yes, yes, Lordship, they paid an amount of rupees.
That minus 20%.
No, minus 20%. They are filing the affidavit by deducting 20%. But that is not justifiable even after an elapse of 4 years of time. Lordship. I waited for 4 years of time. They did not act upon immediately, so Lordship.
Yes, you have given him 80%, that means.
My lord.
Due to a settlement made.
So there, my lord.
You have forced him to make the settlement.
There, let the affidavit being on record, my lord. Affidavit is with me, Lordship. They given me one copy. And so Lordship may kindly take my copy also. I will get one copy from them.
I cannot take your copy. It has to be signed
Lordship.
by the registrar and what. Yours is not signed.
Page 66.
And mine will be better copy than yours also.
Page 66.
Page?
66.
Yes.
They deducted 20% after an elapse of 4 years. And I had to come before this court seeking my legitimate.
Correct. You see, why did you come to a settlement with him? So that he gets the money fast. That was the reason he signed. And that also basically forced him. Unequal bargaining power. And in fact, this is basically blackmail in a way. Forget unequal bargaining. He's supposed to get 100 rupees, but you most probably have said that, look, if you say 80, we'll give you immediately. He said 80, you gave him after 4 years. Double loss for him.
That is there, my lord.
That is
He has signed, he has agreed, my lord, to receive
this is not enforceable. This is not registered document.
However, my lord, in the
Section
meantime-
17 of the Registration Act bars. This is not admissible. No right flows to you because of this.
Very recently, they paid an amount of rupees 7,07,162. 80% amount has been paid in the meantime. Still, we owe another amount of rupees 4,46,766. We owe that amount also.
Now, and he's got the money also. Now he's going hammer at Congress. He doesn't mind.
Let the affidavit come.
Huh?
Being on record.
You have to pay this amount of.
Madam, already on 27 to 2025. Last, in the month of February last. After 7 lakhs, 71,000. I admit.
But Mr. Counsel, when is the date? No date is here. You said 4 years.
But Lordship, in their affidavit in opposition, they mentioned the date as 3rd and 4th January 2022. They have mentioned in their affidavit in opposition.
Okay.
So that is admitted by them. That is simply an undertaking, Lordship. Not agreement. Simply an undertaking, Lordship, not an agreement. That cannot be an.
It is not even an undertaking, it's a declaration.
Declaration.
Yeah. You have declared. He's an unreliable person, so now he's saying that no. And this is not under oath also. It does not bind him. It's not an affidavit. So what remains? You have got to pay, Mr. Counsel, what remains?
Yes, another 3,75,000 per affidavit. 3,75,000 is required to pay. But we owe 4,46,766.
No, I'm not going into whether it's 4 lakhs or 3 lakhs, they will decide. If you feel that it's not the correct amount, you go to the transfer.
Now, even after an elapse of 4 years, Lordship.
No, I'm not on that.
Deduct 20%.
I'm not on that. What I'm saying is that 20% according to you may be 100. According to them, it might be 99. So I am not going into the issue of whether it is 100 rupees or 99. Whatever they say is correct, they will give. If you say that this is wrong, you go adduce evidence in the civil court. That's all. But 20% cannot be deducted.
Lordship,
Whether it is 100 rupees or 99 rupees, I do not know.
Lordship kindly grant me 100%. That is my humble plea. 100%.
You're not even understanding
Whatever
the,
may be the amount, but
Mr. Counsel, you're not even trying to understand what I'm trying to say.
I understood, Lordship.
I-
I understood your words.
Okay, right. I heard
TK Mishra.
Mr. T.K. Mishra, learned counsel for the petition who submits, also heard Mr. G.K. Bokaliel, learned counsel for the respondents. All the respondents. The petitioner, Mr. A. Chaliha appears for point number 7. Okay, 1 to 6, then 1 to 6.
1 to 6.
Mr. T.K. Mishra, learned counsel for the petitioner, submit that the petitioner's vehicle hire charges amounting to rupees.
11 lakhs, 53,000.
So you have been paid this 11 lakhs.
No, Lordship, I was paid only 7 lakhs, 7,162.
7 lakhs, 7,000.
162.
Okay.
That is paid.
Submits that the petitioner's vehicle hire charges. Where is your vehicle numbers?
It is
Where
not-
is your vehicle numbers?
It is in my petition, not in their affidavit, petition.
I'm looking at your petition, Mr. Counsel, which paragraph?
Yes.
Please on page 20. Page 20.
Only one vehicle, Lordship.
Okay.
That was used for.
In relation to.
Yes.
In relation to. Amounting to rupees 11. What have I said?
11,53,928.
In relation to vehicle number AS01
AS01 EM 6966.
6966 has not been paid in full, though the petitioner has been paid 70,162 during the pendency of this case. Correct?
707,162. 707.
Acha, 707,162 during the pendency of this case. That is on which date?
27/2/2025.
27 to 2025.
Page 64.
The petitioner's counsel submits that the petitioner, that though the petitioner's claim bill for vehicle hire charges was rupees 11 so, the respondents have proposed a one-time settlement with the petitioner to be wherein the settled amount, the compromised amount would be paid immediately if the petitioner was agreeable to deduction of 20% of his bill, of his outstanding bill. Full stop. Accordingly, the petitioner was made to sign a declaration certificate stating that he was agreeable to the reduction of 20% from his outstanding bills. Which was executed by him on when?
On 3rd and 4th January 2022.
Mr. Counsel, this is the chief minister's meeting.
Yes, Lord.
When did you sign the declaration?
A declaration, there is no date in the declaration, but in their
When
affidavit in opposition, they mentioned the date, Lord.
Where?
In their affidavit in opposition.
You please know the facts. You don't know any facts, right? As the affidavit of as the additional affidavit of the respondent number 2 is not on the record, it is to play the same on the record. Let's have it to it. Next.
I think also we pay for some time.
Mr. K. Gogoi granted how much time? 3 weeks time to file affidavit in respect of the vehicle hire charges to be paid to the petition.
Oblige, Lord.
Regarding not payment of contractual.
Yes, what is to be done?
I'm not aware, file our affidavit, you may file, affidavit in reply.
You want to file affidavit in reply?
But
No, you take a stand. You want to file, you don't want to file. If you want to file, I will record it. I don't want you to waste my time or I to waste your time. While in the midst of a submission, you will suddenly say you want time. I don't want that. What do you want?
but actually, they have repeated in page number 23 that 75% of the work is completed now.
So,
But they have not admitted the exact amounts method. Page number 23 method. According to the foreclosure report, it was mentioned that due to severe flooding and waterlogging conditions that persist for the next 2 years of the project implementation, it was not financially or personally practicable to undertake the reconstruction of the project. The report further elaborates that due to the flooding was extensive damage to the existing foundation work. Then later on, as per completion report, in accordance with PWD format, it was discovered that the contractor had completed 75% of the work in all aspects.
My lord, the date of administrative approval was expired on 26/7/20.
but you made him do the work. Expired when? 26/7/22.
It was expired.
Correct.
And
he did the work till prior to that.
but departmental financial committee did not accord to the revalidation of the earnings.
Well, they have to do it.
Because of, my lord, unsatisfactory field status.
Unsatisfactory
Field status report.
field status report. Where have you said that? Unsatisfactory field status report. Where is that?
My lord, in page number 31 of the affidavit in appeals.
What is this field status report? What does it say? What is this field status report? Have you got the field status report with you? Whose affidavit is this?
Affidavit by respondent number 3.
My lord, page number 21.
Huh?
For all the response. My lord, page number 21, para 7,
20,
21,
21.
para 7.
Yes. 21, para 7. There's no para 7 in 21. Para 22, page 22, there is para 7.
Para 7, my lord.
Huh?
Para 7.
Yes, page 22
Affidavit in opposition. Para
of respondent number 3.
or respondent.
Yes. Para 7 is at page 22 in my copy. Please read it. Please read it. How does it say?
That as regard to the statement made in para number 7 of the petition, the incident dependent basically state that during the inspection conducted by the divisional officer at the in Mumbai on 26 December, it was reported that all plants got damaged in the project site due to several dust and inspection. Despite making efforts to sustain the safety, the task has proved to be extremely challenging. One of the primary reasons for this is the low-lying situation of the project site, which has caused issues with soil drainage. Additionally, the malicious activities of enforcers have occurred, exacerbated the problem and made it all the more difficult to reclaim the setbacks.
This is a completion report.
Page number 14, madam.
Huh?
Page number 14.
40.
14, 1-4, madam.
1, 4.
In the petition, madam.
1, 4. PS 1, 4.
As per this report, my lord, 80% work already completed, madam. Page number 15 last.
No, you see, my question is, where is this unsatisfactory field status report? Mentioned in page 31. I want that. Okay, right. What is your name?
P. Hazarika on behalf of SR.
Mr. P. Hazarika, appearing on behalf of Mr.
SR Raha.
S.R. Rabha, Learned Counsel for the
Soil Conservation Ground.
Soil Conservation Department shall produce the unsatisfactory field status report, which has been mentioned in the letter dated 21/3/25, issued by the Joint Secretary to Government of Assam, Soil Conservation Department, bracket, Annexure 6, Roman 6, page 31. By the next day. This is the matter after 2 weeks.
Please. One.
As per the my lord have directed us to see whether that particular notice of serve on it. That part means I have seen instruction on it.
Otherwise, this issue is covered by a lordship order. Exactly on the same point. That such suspension cannot remain for more than 90 days. The lordship should kindly come to paragraph 10. In view of the provisions of clause 15(2) of the 1980, para 10. In view of the provisions of clause 15(2) of the 1982 order, this court is of the view that continued suspension of the petitioner's previous license without issuance of a show cause notice is not sustainable, and the same would be against the provisions of clause 15(2). Accordingly, suspension of the petitioner's previous license being beyond 90 days, pursuant to the order that is found to be unsustainable and is hereby set aside. In view of the above, petitioners should be allowed to run the fair course of as per their license.
Yes.
There also issue is defined also. The so cause notice issue in a period of 90 days.
Okay.
90 days lordship, that was lordship, he declined to accept it lordship. Accordingly, it was hanged in the house of the lordship petitioner in the presence of the governor lordship. Certificate is there. I place it by way of affidavit lordship. Then petitioner can also reply to it. Here, certificate.
Out here, the show cause was issued
So
within
called
90 days.
Lordship.
But he did not
He did not receive
Reply.
it, Lordship.
They are received.
Declined to receive it. Accordingly, it was hanged in the house of the petitioner, Lordship, in the presence of the blessed man, Lordship. Certificate is there. He is given the undertaking, Lordship. And so, Lordship, I will place it by way of affidavit, then he can, Lordship.
My lord, this statement is not correct. If your lordship should kindly come to one subsequent letter at para 8 of our reply, my lord. Please come to para 8 at page number 120. That with regard to this statement, page 120.
Yes.
That with regard to the statement made in paragraph 7, the deponent humbly begs to state that he has received the show cause notice dated 27/11/24, while memo dated so and so. After going to the said notice, he has also found mention of another show cause notice dated 21/7/23, while memo dated so and so, which is enclosed with the said notice dated so and so. In that show cause notice, the deponent has filed reply wherein he stated he has never received the notice dated 28/7/23. So, my lord, we have annexed that, my lord. That's good. This one. My lord, this 27 letter. In fact, they served a notice on 27/11. Well, you see, my lord, this is on 27/11/24. With reference to the subject above, I am to inform you that you were served so-called notice by this office letter dated so. So in view of this, my lord, this honorable court asks them, show the acknowledgement, end of the matter.
That is before your Lordship. Today I have got instruction, Lordship. It was on 22/7, it was, Lordship, hanged in the house of the petitioner, Lordship. It is there, Lordship. I will put it by way of affidavit, Lordship. As because on that particular point, my Lordship directed us to, Lordship, less the.
Okay. No, basically what they're saying is that serving of show cause notice need not necessarily be by physical giving also.
Could be.
It can be by pasting on the door.
They have their own stand. I'm not saying that this acknowledgement is correct. But they say I will serve. So please show.
That is the service purpose. We complied the provisions of order 5, rule 21,
No, my
Lordship,
lord,
the CPC.
that
We
order
complied
5
the
CPC, we know.
We
But in
complied.
the context of your statement, we are saying.
We complied. We have affidavit, we'll place it, Lordship.
Let them file an affidavit, my lord, will reply to it.
Mr. Overall, learned counsel for the
State respondent, Lordship.
state respondent submits that show cause notice dated 21/7/23
Lordship.
was served upon the petitioner by hanging the same on the door of the petitioner's house
In the presence of the blessed man.
in the presence of the
Blessed.
village head. He submits that he will place the same by way of an affidavit.
Lordship.
Yes, here for Mr. Here for appear for the corporation department. Anything to do? Any affidavit? Anything? How much time?
Within a period of 10 days, I will file, Lordship.
Unless the matter of 10 days.
Oblige, Lordship.
My lord, there is an interim order in continue.
Interim order to continue till the next day.
Oblige.
Date. Put your lordship, give a date after. ठीक है.
Yes,
I need further 2 weeks time, madam. The under secretary has been moved.
this is the day over granted a further 2 weeks time to find affidavit in the position. This is a matter of fee.
Always, madam.
May I please? Matter relating to settlement of the ferry service. And here it is in this case, private government did not comply the terms and conditions of clause 8 of the annexation. As per clause 8.
Yes, now this case, just a minute, just a minute.
Yes.
Yes, yes. Tender clause page 23. Page 23, clause 8, next page number 24.
Yes, which one, which do you want?
8.
Page 23, 8.
Yes, 23, 8, next page 24. If there are more than one co-partner, NOC from the co-partner to be submitted. The land service that begins the ferry service will be effective. The ferry service. In this case, you know, private authority number 5 here. NOC from the co-partner.
From the co-partner.
That's only my case.
So,
And similar situation will one coordinate bench or already decided the sale. Again, the third method, the financial sound certificate has not been submitted from the.
no, so what happens if there are more than one co-partner? What happens?
Yes, he has submitted the NOC from the co-partner.
Then what happens? So,
And then if you know that, the settlement order passed in favor of the, respondent of 5 in violation of the code.
violation of which order?
The terms and
Look,
condition of the.
you see, if there are more than one co-partner,
Yes,
NOC has to be submitted
yes,
from all the co-partners.
yes.
Now, he has not submitted.
He has not submitted.
He has not submitted the, so
NOC
then,
from the co-partner.
so what happens? So he does not get the tender, he does not get the work.
Yes, but respondent number 4 settle the ferry service in favor of the respondent number.
I don't know what, I have no idea what you're talking.
Lordship, may
In which case? Settlement,
It's
ferry
settled-
service, which
ferry
ferry,
ser-
which ferry service?
ferry service, Borali mere Gadua via Borbari, serial number 5 of the NIT case.
Huh?
Page
Where is the NIT? Show me the NIT.
Page 9,
Here, 19.
serial number 5.
So he took part in which one?
Which one? Borali mere Gadua, serial number 5.
Yes. And 4 also.
Yes, I am one.
Huh?
I am also participated, respondent number 5.
In both, in 4 and 5, you both participated. Then what happened?
Whatever method, as per clause 8,
He is supposed to submit co-partners, no NOC. So did he submit that NOC in both the ferry services or not?
one.
Which one?
Serial number 5, method, text 9.
So serial number 5.
Yes.
So for this Barali Mari, he submitted the NOC. Correct?
In this case.
So for Barali Mari, for 5, he submitted. And he got the tender.
Yes.
What is wrong?
He has not submitted the NOC from the co-partner as per clause 8 of the NOC.
In both the ferry service or in one?
Is serial number 5. He has got the 2 mailer.
He has got the 2 what?
One is mailer, serial number 5, another is another mailer. I am not on that mailer. I am confined with the serial number 5.
He has not submitted co-partner NOC in serial number 5.
Yes. He has not submitted the NOC from the co-partner.
In serial number 5. Is it?
Lordship, we have filed our affidavit, page 91, running page, my lord.
Yes. He knows
But
what
he's
is.
otherwise not eligible for the,
Anyway, I'm not on that.
yes.
First of all, let us see
91, page 91, paragraph 6A, my lord.
6A, yes. In regard to the respondent number 5 has submitted land valuation. So, Samuel,
19 bigha in his own name, that
So,
covered the bid value.
okay. So one point. So 19 bigha is standing in his own name.
Own name, and he's covered the bid value. So
And
NOC is not
it's
required.
covered the bid value.
Bid value.
So there's no question of
No
NOC.
question of NOC from co-partner there. And nothing, my lord.
But as per here is a co-partner that in his Jamabudi copy, and you see the document.
Show me, where is it?
Yes. Page start from page 32.
32.
Yes. No.
32 years. Unfortunately, yeah, yes. But even I don't have 32. I have got 31 and 33.
Yes, 31.
Only you have got 32.
Yes.
You go sit in one corner and write your own order.
Yes, it's pretty.
Huh?
Yes, 31 is. Yes, yes. Yes.
Ah.
Yes, the Kopata there, yes, Mughal, Osmana.
Huh?
Yes, the Kopata there, Mughal, Ishwas.
Mr. Counsel, only problem is you are the only person amongst all of us who has got a complete set of documents. So we don't know what you're talking about. Because you're the only one having that document. Page 32, none of us have it, only you have it.
There is 31 also, 31. And the page below the another page below is 36 also there. There is also another Kopata.
What was the document that he submitted?
Which documents?
Lordship, the land valuation certificate, his own name.
What is the pass number or pata number or dag number?
That
or
land
something?
valuation I have annexed in my affidavit, my lord.
Connection A.
Yes. Annexure A, my lord.
Covered by dag number.
That will be issued by the circle of the office of the deputy commissioner. So
Usman Ali, you are Usman Ali.
the private respondent is Osman, he is Iman Ali. Petitioner is Iman Ali.
Okay, now Usman Ali, he has got this. So you show me that his land is also owned by a co-patadar. Where?
Yes. Okay, 32.
32 is, I don't have it. Neither does she, neither does he, only you have it in your petition.
31. Here is the speaking while the
Huh?
paper, while the while missing the paper. 32 is.
No one stitches paper.
Page 31 is also here is the Kopata, so many Kopata.
31.
31 there is so many Kopata.
31 is, but it is pertaining to dag number 424.
424.
424.
Yes, and next is 36. There is also Kopata. Muzammil Hussain, tag number 199.
This, okay, when we say dag number, can there be, so the dag number means there be someone else also is there.
Page 39 also.
You see, come to page 32. Name of Pata holder. Meglal Biswas is there.
This is my page 32.
Your page 32. Your page, I'm talking about his page 32. If he's got a page 32 here, it is after page 30. The difference, he's made it 32, 31, 33, that's why.
That instruction, the circular office, they will get my love, because the dag number, patta number, everything, the land value certificate, everything issued by the office of the deputy commissioner.
Page 39 also will there is so many.
39.
39.
Four, two, six.
Also will say 44. 55.
I thought his case was different. I thought his case was with regard to
Submission of, not submission of the NOC of the co-pattaker. But as per affidavit, 19 figures land is his own name.
Huh?
That's why NOC is not required. As per the affidavit, fine.
no, but you see, in his own name, but with regard to which land? You have very conveniently mentioned only the area.
Yes.
You have not mentioned the dag number and pata number.
That instruction I will get lordship if required. I will produce the original record if there is anything in the office of the director.
Yes, because you have said the respondent number 5 has submitted land violation certificate of an area measuring 26 bighas, 3 kattas, 9 lechals.
Lordship,
Out of these 19 bighas, 0 katta, 0 is standing in his own name.
Lordship, may kindly fix them on Friday. I will get the original record.
So we want to
Lordship.
see
My lord.
how much is in his name, the area. The problem is he does not want to file affidavit.
Yes.
He wants, that's why I'm not allowing him anymore.
My lord, I'll produce
I'm
the
not
original.
allowing you to file. You don't want to file, you're just wasting time of the court. You want to delay the matter. So I'm not allowing you to file. If you want to file, you pay costs now.
Friday, my lord, I will produce the original
Okay.
record regarding the land valuation and the patta number, duck number, everything. Available.
Miss MD Bora, Learned Standing Counsel for the Transport Department, submit that she'll produce the official report on Friday.
No.
Friday, Monday. Monday.
As per my lord, can-
This is the matter on Monday.
Okay.
You want to file affidavit, you pay cost.
The documents are with my learned friend, that is with the media, and the same documents are there.
Yes.
With my learned friend, thank you.
Okay, right. The petitioner is the counsel, Mr.
Yes, sir.
S. Ali, the learned counsel for the respondent number 5, submits that he will not be filing any affidavit as the respondent number 5 will be supporting the stand taken by the state respondent.
Lordship, in this case, there was a big order passed, it was 10/3/2025. Lordship, thereafter, the appeals declared against the English order, their lordship, the matter came up for the Egyptian court, if the order lordship was vacated, and the lordship of the district commissioner was directed to lordship, bring to a conclusion the proceeding. Bring to a conclusion.
But this has become infructuous.
Yes, but lordship, this petition has not been closed, lordship.
No. But if the,
This also involves another issue is because there is a special provision regarding oil companies. But I think that issue has to be decided.
just tell me what is the case. Give me the division bench order.
Today order, only today it was listed and order passed today. May I pray for Malak day after tomorrow so that I can place the order, Malak? Because
Let it be clearer then.
challenge the suspension order, Malak. Suspension order, if the honorable division bench is
What have you
directed.
challenged here in this
Lordship,
petition?
we have challenged not only suspension order because lordship suspension order was never provided to us. Our case was that lordship in this case, lordship with DC and lordship seized the trade license. Thereafter, lordship we had kept it.
Trade license, you are having a petrol pump.
Petrol pump.
Correct.
There, on lordship 9/11/2023, the DC along with officers from the legal facility department conducted an inspection and some anomalies were alleged, lordship.
Were found.
Lordship. Thereafter-
Malpractice.
Malpractice, lordship. Thereafter, lordship, the trade license on 9/11/2023, lordship. And lordship, a show cause notice was also issued to one of the lordship partners of the petitioner's lordship. And that partner had given a reply on behalf of all the operators of the petrol pump. Thereafter, lordship, our case is that in the meantime, the oil pump authorities approached us and they gave a warning that if you don't run the petrol pump, since it is not functioning since 2023 or not, November 2023, we will lordship terminate the agreement, whatever agreement was there. Now, lordship, our agency had kept the trade license seized from 9/11/2023. Show cause notice on 1/4/2023. In the meantime, lordship, they brought up one suspension notice in 4/12/2023, which was not issued to us, lordship. Now, lordship, our case is that since there's a special provision for retail outlets which are run by different oil companies, lordship, the DC doesn't have the power to investigate also. Since machines are owned by the oil companies, in case of any tampering, lordship, oil company will investigate such machine. DC doesn't have the power, nor DC has any lordship, any equipment to lordship investigate such lordship machines. That is our case. Since there's a special provision.
So then you are allowed to run
In interim.
by the interim order.
DC did not comply. DC lordship gave us warning that he's going to lordship not comply. by any means is not going to comply with the order, we filed the contempt case, Lordship. Thereafter, an appeal was filed. Lordship, after a month, Lordship, the appeal was, it came up today. And the honorable court decided that the interim order should not be read in such a case. And Lordship also, the director DC2 Lordship finished the show cause notice, that proceeding under the show cause notice within 4 weeks. But now there is another issue involved is that because Lordship says there's a special law.
What is the special law?
Lordship, special law, Lordship. And
No, but can there be a law allowing you to continue a trade even though you are charged with malpractice?
yes, Lordship, that Lordship.
So you see, no, what I'm saying is this. If the division bench has allowed the issue to be decided by the DC, now the decision to be taken by the DC now will cover everything. If he rules in your favor, then naturally your license will be given back to you and it will have to operate the petrol pump. Now, if he doesn't rule in your favor, you'll have to challenge the DC decision also. Supposing, you see, because unless you challenge the DC decision, this cannot stand on its own. So why don't you, so in that way, this writ petition has become infructuous. Because the decision of the DC, if it's against you, will have to be challenged.
That is Lordship, if your Lordship wants to dispose Lordship, liberty will be given also Lordship the observations made in this proceeding, but they may not be prejudiced Lordship in case we want to equal this court for the subsequent.
There is no observation here.
Lordship, in the order till 10/3/2025, there was some observation Lordship, that observation may not prejudice.
That has already gone, my lord, because
That,
that's set aside by the.
now, when the division bench has set aside the interim order passed by this court, then what remains?
Yes.
Then Lordship, only reason may not, nothing may prejudice any objection in this proceeding, may not prejudice any subsequent proceeding.
In fact, the observations here might help you.
But there will be take advantage with the DC has jurisdiction, Lordship. Our case is that DC does not have jurisdiction.
That you have to challenge a separate writ petition, not in this writ petition. Because that decision will come, that decision is going to be made in pursuance to the division bench order.
After 4 weeks.
So that is what, huh?
Direction has been given to complete the proceeding within 4 weeks. My lord.
Other than the letters also be up to the constitution.
Not, my lord, that would be, Lordship will.
It'll be clearer once the order is.
Right. The counsel for the parties submit that the interim order dated 10/3/2024 has been set aside by the division bench in WA number
Lordship. WA number 142 of 25.
120,
142.
142 of 25. And the issue raised by the petitioner is to be decided by the concerned district commission. In view of the above, it appears that the present writ petition has become infructuous. List the matter on Tuesday, on 6th. On 6th, wherein the counsel for the parties shall produce the order dated 30/4/2025, passed in WA number also, So basically, you know the fate of what's going to happen. One more date.
Just to be clear.
Obligement.
Item. So
It's a settlement of a ferry service, that's just telling you.
the pleadings are complete. What about private respondent?
There is no private respondent.
Private respondent, there is no private respondent. There is no private respondent, they wanted to quote a letter. This was put to channel because my ferry service existing till 2026.
Yeah.
26.
Till which month?
31st of January 2026. It is for a period of 2 years.
Okay, so it started in 1st February.
31st of
First February 24.
March. 31st of March. 36.
31, 3.
26.
2026.
He said 31 January,
31 March.
March. So that means it's from 1/4/24, from first April, from this month.
Tell you also, man. Tender was total. I participated in the tender.
NIT dated
NIT is dated, my lord, 13 to 2024.
13 to 24.
2024. I participated, then I completed the section of the fed. After the completed section of the fed, I was found to be post eligible area.
H1.
Yes. Then accordingly, my lord, I was, government applicable was there. And accordingly, I was, settlement order was passed. Settlement order was passed, my lord, on 1/9/2024. 1/9/2024. At page 27. 2020. Settlement order was passed. Now, on the basis of settlement, I was running the ferry service. Now, once I was running.
So this, just a minute. So the ferry service is for 2 years,
2 years.
Yes.
but settlement is from September.
Yes, we did.
The process is take some time. And then
Okay, so, but he actually starts running it
Yes.
prior to the settlement order being issued.
Right,
Is
once
it?
the settlement, once it is taken over on that day, it will be start operating. It
So
is
that
not
means
that.
2 years will be
Like
counted
fishery,
from
my
1/9.
lord, Fishery also,
No.
I know from the date of taking over position issuance.
So
Now,
it
my
is not exactly for 2 years.
Yes. Now, my lord, we were running it. Suddenly, they have issued an impugned order on 28/1/2025.
28,
1/2021, two orders, and one is 29/1/2025, saying that pursuant to a government, if you see at page 37, 36 and 37. See 36 and 37, these two orders are being.
Yes.
In first, in reference to the subject, I am directly requested to go for a first tendering at the earliest by cancelling the existing settlement of so and so for a period 2024-26. If you see the next order, page 37.
Yes.
The office order, the order issued pursuant to government order concerning the settlement of so and so stand cancel as per government in transport department letter dated 28/1/2025. So when I came to the court, moved this matter before the court, I said that you pass this order, a decision you have taken, maybe an admissible decision you have taken. But at least this civil counsel, at least I should know what is the reason behind. That was the case. Now my learned friend appeared on the day when it was used and said that I have brought the record with me and I found that you have violated the terms and conditions of the NIT and you have subletted or subleased. That was their ground before the court, but he doesn't speak of. Whatever maybe the court said, what we'll do, they will not go away with the first tender to be floated, and in the meantime, they will come with an affidavit. And accordingly, affidavit has been filed and we have given a reply. Our reply, which was given on record, he said, what do you mean by sublet or sublease? There is an agreement. I told my client, what is that whether you are sublet or sublease? There was a notarized agreement with that particular affidavit, not an agreement, affidavit, with two of the person saying that what we do is not that subletting. They will take care of it. That is what I can read the context. Secondly, I have read what do you mean by sublet or sublease under the law. Sublet and sublease, I have seen the law under Transfer of Property Act. If your lordship looks into it, Transfer of Property Act and the Registration Act. If it is more than 100, then my lord, there has to be compulsory registration. It is for a period of 2 years. So if it is not backed by any law, whether my lord, if your law, that I will explain, I have brought in my affidavit. But my first contention is that when you serve the notice to me, my lord, when you serve the notice, it doesn't contain any reasons order. For what reason you have terminated? Very well, you take a decision, my lord. But at least I should have been informed and I should have been given a reply. Thereafter, you take a decision. My lord, it is not a case, a pre-decision and a post-decision. You cancel it, my lord. I come to the court. You have every right to take a decision. But whether I have no right to give an answer.
Well, that aspect now is gone.
No, that aspect is not gone. This aspect is.
No, because now post-decisional
They have not taken post deletion. No? It is not a case of post deletion.
They have not taken this.
No, what that is why.
No, so we'll close this. Let them issue a notice to you answer and let them take a decision.
No, that is why when the first day I came to the court, I said that this is a decision absolutely on the face of it, there are judgments of this court, of this honorable Supreme Court. So if you decide the issue which leads to a civil consequence, I think a notice has to be served. Well, when I read this order,
No notice, you issue notice to them.
no notice.
Lordship. Lordship, may kindly have a look, management and control of credit group.
I have
First of
stated
all,
ferry service sublet or sublease.
rule
Some
seven,
complaint has
rule
been.
7. I have flag mark, my lord, 11 question.
Rule 7.
7. First, rule 7, my lord.
Yes.
May I read, my lord?
No, it's not right. I'm not on that. I'm not on. You might be having the best reason in the world
Lord,
to cancel the tender
No.
or cancel the settlement. But it's his right to be informed of the reason why his settlement is going to be settled or taken away. It's only that. It's the principles of natural justice, not the alternative partner. That's the basis for this courts also deciding cases after issuing notice only.
Lordship. Lordship,
Because there's prejudice is going to be positive, that's all.
that's right, Lordship, but my lord, in our affidavit,
Yes.
we have stated all this, why we have taken that decision. Because as per rule 7, Lordship, kindly have a look.
Okay, so since
The-
that has been done, now we can decide this. But then,
As,
yes,
as my learned senior has stated, the sublet and it's
Sublease.
different. Subleasing is different, but in rule 7, what is written, my lord?
yes.
The lessee shall not sublet, encumber or
Let
transfer.
let me see the thing.
Yes, that agreement that the petitioner
Agreement,
had
yes,
with the third
yes,
party,
yes.
that I have annexed in my affidavit in page 45, running page. Page 45. And 46 is relevant. May I read my last page 46?
Yes.
I, Sri Motiur Rahman, he is the petitioner, son of such and such business, a resident of village such and such, my lord, issued by the executive engineer, England of the Transport Division, Ulubai, such and such, but I am being the resident of Borpeta district, facing communication troubles to take care of the ferry service, but as because of which I do hereby authorize Mr. Such and such Zohir Islam, such and such, and Mr. Soneshwar Hussain, such and such, by profession, business, such and such, and run to take care and run the ferry service smoothly. That is Sunari ferry service, the case in concern during my lease period, which effect from 2/10/2024, and do hereby execute this authorization letter on 1st day of October 2024 at Goalpara in presence of the following witness. It's an authorized agreement, my lord. You have annexed and so many complaints we have received.
Where is the complete? That's all. It's this much only.
This is the authorized, notarized agreement between the petitioner and the third party. He have given the third party to take care of the ferry service because he is unable to take care. He could not take care and run the ferry services. But as for the agreement that he has entered with the department at page 28, he has signed this agreement, page 28, Annex of 5. If there is a valid agreement, is there any notice to serve before cancellation of the ferry service, my lord? With the agreement, he has entered Annex of 5, page 28 in the writ petition itself, my lord. His signature is there. Motiur Rahman, he has signed with the director of IWT. All the clauses are there. This is page 29, relevant rule clause is 15. The lessee shall not sublet the ferry. This also in the agreement. And agreement is alive. Is there any notice to serve to the party to cancellation of the ferry services, my lord? Then lordship, the rules 36, my lord, may kindly have a look that I have provided to my lord. 36. 36, 1, my lord. I have flag mark, my lord. 36, 1, my lord. Lordship, I got it, my lord.
Yes.
If the lessee violates or fails to perform any of the covenant contained herein or in the lease, he shall, in addition to any other liability, be liable to have his lease cancelled by the secretary to the government of Assam. Government of Assam in transport department, and in that event shall not be entitled to any compensation or to the refund or any portion of the ferry rent, advance or security or of any kind. Well, he has entered an agreement. Page 20 is very clear. He has signed the agreement. He knows all the conditions to run the ferry. It's a ferry service, my lord. It's not a transportation of goods or something else. There are so many so moto PL files before this honorable court after the incident of ferry service. So many persons died. This is the so moto PL. This honorable court is monitoring the cases. So lordship, we cannot go like that. He cannot take care of the ferry services. He cannot run the ferry services. We cannot have enough time to issue so-called notice to him to reply why you are subletting the ferry service, because as per the tender condition, as per the tender agreement, it is very clear, my lord. It is automatically cancelled. He is well known the conditions written in the agreement. So lordship, why the notice is required? It's regarding the life of person, my lord. It's a ferry service. The commuters are will be suffered, my lord. There are so many incidents happened earlier, my lord. These are the Somoto PIS files before. This honorable court is monitoring this matter, lordship. So many direction has been given to take free actions against those types of lessee, my lord. So lordship, there is no time to give so-called notice. It's not a matter of suspension matter. It's not a service matter. We issue suspension notice, we given so-called. It's a matter of life of the people, my lord. It's up to my lord, my lord. Now we are the departmentally regulate the ferry service right now, because we have cancelled the ferry service with the petitioner from the form 110/2024.
So no one is running the ferry service right
The departmentally we are running.
now.
Yes. Because we are going for the fresh tender, but this honorable court has interim order not to go for fresh tender. We are running the ferry service department.
Where is the NIT
Lordship.
for this, for the earlier NIT?
No. The NIT space agreement is there, my lord, page 28. They have annexed in the writ petition, my lord.
Page 28.
Annex of 5 years, my lord. He has signed in the agreement, the director. He knows all the conditions, what will be the consequences if the subletting is done by him. The rule is very clear.
So according to you, this settlement has been cancelled due to this subletting.
Lordship. In fact, we have received complaint regarding there is no insurance in the boat and driver license, etc. This honorable court has directed us while monitoring the issues regarding the earlier incident, strictly comply with all that. Lordship, one line I'm just reading. The authority constituted under 2018 Act should develop a mechanism for checking compatibility of the safety jacket and audit of every vessel at least once a year. General signal of the weather condition should be installed at every ferry center, exhibit the current weather condition and the life jacket, etc. All these have been given. Direction has been given, Lordship. So immediately when we received this complaint, we have done one inquiry through the executive engineer, Lordship, that I have annexed in my affidavit. And he has also saying that he is subletting the ferry ghat. So immediately you have cancelled because if something happened, who will responsible for that, Lordship?
But then how do you know what complaint has been received to you with true or not?
Lordship,
The document.
we have done one inquiry, Lordship, by the executive engineer. That I have annexed in my affidavit. Lordship. This is page 50, my lord. Executive engineer has written to the director, Lordship. Annex 3, my lord. Page 50.
Where is the settlement with the other person?
There is no settlement with the other person.
It's,
We departmentally running the vessel.
This is with Johirul Islam.
That, Lordship, I have annexed in my affidavit, page 45.
Islam
Page 45.
and Sanawar Hussain. Okay, both are here.
Yes, madam. Page 45, relevant is page 46. This is the affidavit the petitioner had made with the private person. Then authorized notary agreement, madam.
Yes.
First, I will take to your lordship about the order that has been passed. My first argument will be the impugned order doesn't have any reasons at all. One, and notice has to be provided, which has not been done. It is a basic on a principle violation of principle of natural justice. Number two, while learned friend has sold some PIL, saying that for safety reasons, this and that is a reason that immediately we took an action. My lord, if that is a case, that is for the safety reason, and there is a PIL which has been filed, in the impugned order that should have been spelled out. No, nothing has been spelled out. And they said, if your lordship looks into their complaint at page 44, complaint has been given by one NGO. Kindly see, my lord, at page 44 of their affidavit. This is by one NGO has written to the director, Department of England Water Transport, Ulubari.
Page?
At page 44 of their affidavit.
Yes.
Kindly see. Prayer for cancellation agreement of so-and-so. We have the honor to inform the so-and-so on agreement by so-and-so. However, the above person have transferred the so-and-so to an agreement and enclosed in lieu of excess money, which is double to the government agreed revenue. It is a gross violation of rules and regulation. Excess money is now being collected from poor money. Poor people as increased fare. Apart from this, the boat being used for care does not have insurance, driver license, etc. Now, the only basis of that, if your lordship at page 50, which my learned friend has shown before this honorable court, at page 50, there is some letter without, they made some inquiry without giving any notice to me. And my lord, your lordship is not, it is not that on the basis, not on the basis of some NIT, state largesse is involved. I participated. They cannot say that no notice will be served to it. Kindly see, this is at page 50 regarding compliance. So, my lord, the director, a letter was issued from England Water Transport Director and said, this is what, and this is the report which you have furnished. So, my argument before this honorable court, they cannot take the stand that there is a PIL. PIL is something else. My whole case is that you have taken a decision without giving a notice to me. That is why. You should have given a notice to me before terminating. If it is, maybe there is a violation. Let us say there is a violation of sublet of or sublet of ferry service. At least a notice should have been given to you. Then you can take whatever decision you want to take it. That this is a violation, you have done it, this is the amount to sublet. After cancellation, then you have, now you are coming to the court and say that this is what we have done. Now, in this context, how the apex court has dealt it, whether it can be, what is the apex court judgment? I'll say two judgment of the Supreme Court. 1993, that is Sterling Computers matter. Sterling Computers 9. What a Indian I'll just give a copy to your.
Yes, can we hurry up?
Yes, I'm sorry.
No, it's my fault actually. Because I didn't know I was going very slow today.
I just 2 minutes.
I've got one meeting, that's why.
Oh, I'm sorry. My lord, 2 minutes. 2 minutes. I'll just end up 2 minutes.
Just give me the citation
Yes,
and thing.
my lord, Sterling
1993, one
Computers, SEC, page 445, para 18. Can you see para 18? Just one paragraph.
Yes, yes.
Para 18, I'll not trouble with para 18. While exercising the power of judicial review in respect of contract entered into or on behalf of the state, the court is concerned primarily as to whether there has been any infirmity in the decision-making process. In this current reference may be made to the case. The purpose of judicial review. Yes, my lord, 2022, 16 SEC, page 527.
16 SEC?
2022.
527, yes.
16 SEC 5 para 39. A small paragraph. This will small paragraph.
Yes, yes.
5 lines. Natural justice at para 39.
Yes, yes.
Natural justice is an important aspect while reviewing the administrative orders. Providing effective natural justice to affected parties before decision taken is necessary to maintain rule of law. Natural justice is the sole enemy of intolerant authority.
Okay.
Any attempt. Now here, my lord, tender was given and it was set aside. Thereafter, they said that coming to the fact the post-decision hearing given response is.
Okay, got it. Yes, anything? Any citation?
Lordship,
No.
citation,
No.
because the agreement is still valid. When there is a valid agreement, it's necessary to provide any so-called before cancellation and the tender, because he has entered the agreement.
You have to give notice.
My lord.
You have to give notice. How can you do that? You at least you should have given reasons in your. First of all, no notice. Okay, that for sometimes not notice, no notice is not required in all cases. But there's no reason in your order. You could have mentioned the reason. That also not there. You can do it afresh. We will give you the liberty to do it afresh.
My
You
lord,
do it
Till
afresh.
then, departmentally will
Yeah,
run it.
yes, you run everything.
Yes,
But
that is.
but then if you do not complete the process within 3 weeks, then they will allow to be run.
Lordship fixed problem with Panchayat election is going on. From 2nd to 7th after a result. Within 2 months we can.
No, this is my lord. What is this?
We will issue
What,
notice.
there is nothing.
We can issue notice.
You
in
issue
this
notice, they
period.
will issue
Yes,
reply
yes.
and then
After the Panchayat election, we can.
My lord, what
Today is 30th. Panchayat election will be completed on 15th.
15.
Will be
Result.
counted on
my
15th.
lord, may I?
By 20th,
Yes, yes.
20th of May
Lordship.
is Tuesday. By 20th and by 21st, it is Wednesday. By 21st of May, give a decision.
Lordship.
My lord,
Lordship.
what is
If till then, Lordship, we will running the ferry service.
This is an NGO he is doing. We know. We don't have any proof. That's why we know who is running this ferry service. My department, NGO is the main who made a complaint. Otherwise, what was the hurry?
There is a
Your
other
lordship
person
knows.
also.
1 second, I didn't disturb you. Why your lordship knows? In one of the cases, rightly said, 10 years, 15 years back, I told the court, one of the court, that there is no reason, not necessary. Records will speak whether there is reason or not. Records were called for, there is a reason. Then said enough, it's gone. The reason is that each and every case your lordship is right, is not to be committed unless there will be reason in the records. Reason has to be, kindly see, there is no the state large. I could very well understand PIL is something else. State largesse. I participated. There is no default in paying of the payment. Okay, sublet, very well give a notice, say that you sublet, make an inquiry of it. End of the matter. I don't have any grievance, my lord. How can I say something? But principle of nature, in all the case the court said
please follow your lordship is following principle of natural justice. They
No,
can't
no,
take-
that is why we are going to ask them to follow the principles.
No,
of
that is,
justice.
I know, but that order should go. Immediately it should go. Why a particular lordship has seen, they cannot take the benefit of it saying that, no, your lordship has got every right. But this order should go and immediately we should run it. Because
No, no, we will say depending upon the order, they'll give you another 3 weeks, they will compensate for the loss of working days.
They will compensate. They have to compensate.
For the loss of.
Yes.
So
they have to compensate.
that will be taken
If the
care of.
decision taken
Yes.
lordship,
Huh?
we will departmentally run the ferry service. Because there are the
Okay,
local
right.
people.
Yeah, right. Heard Mr. Deegan,
Finally come.
the senior counsel for the petitioner, assisted by Mr. Yes? Also heard Ms. MD Bora, learned counsel for the
Transport department.
transport department. Hearing concluded.
Lordship,
And the-
one thing, it's not a normal PI.
We say dispose of.
Dispose of.
Not save it.
Lordship, it was a somoto PL, not a simple PL as.
No, I know this is a
Yes.
very serious matter
Yes,
because
yes.
you see, the issue is that supposing there is someone dies, supposing it capsizes the boat or something happens, then the thing,
I will never support. It's a very, I have seen a lot of tragic incident has happened. But whether that is the ground,
correct,
no, that is the ground.
that is
No,
why,
we have to- but we are
your
in the-
case is correct. But
Yes.
in some
But
cases,
suppose
we have got to
in
be
that-
slightly careful.
My lord, court of law, there is no emotion. Your lordship will go by
But
my.
this is where human life.
No, it's okay, fine.
Yeah.
Human life is not connected with the present case. That is what I am saying.
Definitely connected, my lord. It's a
May
very
be
serious-
connected.
I'm so deeply obliged.
Anyway,
Deeply obliged.
Deeply obliged, lordship.
27, yes.
My lord, I'm paying for adjournment on behalf of Mr. P. Sharma, standing counsel for FDC.
Why?
My lord, he is not present in scope. He had some difficulty.
His case is that the MAC has got
Yes.
missing autonomous council has granted the settlement. Now that is a covered matter. It's a covered matter. So why does Mr. Sharma want that it should be adjourned?
My lord, he's praying that the matter may be taken up on Friday or Monday.
No, why? It's a covered matter. It's a covered matter, correct? If it's a covered matter, then there's nothing to keep this pending. Who is for the respondent number 9? Notice has been issued.
Yes, notice has been started, he has been filed Wakalat number.
His file Vagadnama, he is not here. Who is the person? B. Dole is not here. Then unlucky for them, they missed the bus. It's a covered matter. Mr. Dole will not have anything to say.
Yes,
Right. Heard Mr. B. Raman, learned counsel for the petition. Also heard Mr.
R. Ghosh.
R.
Ghosh.
Ghosh appearing on behalf of Mr. P. Sharma, learned counsel for the fishery department. Mr. Who is for the MAC? Mr. D. Gogoi appears for the missing autonomous council, while Mr. B. Deary appears for Haji Pokalel appears for 1256. No one appears for the respondent number 9. 156. No one appears for the respondent number 9, even though the name of Mr. D. Dole is reflected in the cause list as the counsel for the respondent number 9. Who's for? Next one. We take this last order, second and third paragraph. Okay. Next paragraph. It is the case of the counsel for the parties who are present today that the matter has been decided, that the issue of whether the missing autonomous council have any authority over the water bodies, rivers, and lakes within the state of Assam has been decided by this court in a batch of writ petitions, the lead case being, give me that.
Page value 52.
Please give me that.
Yes.
The lead case being cannot be 52.
3065.
3065 of
3065, up to 2024.
2024. Name of party?
Party, well, Dibrugarh Fishery Cooperative Society Limited, Dibrugarh.
Versus
State of Assam and others.
State of Assam and others. Stop. Next, give me that. I'll give it back to you. Don't worry.
Well, here,
Give me the judgment. Next para. In the case of huh?
it is already in the record.
Already
Yes,
here.
Yes,
Oh.
page 52.
It is already here. Okay. Sorry. In the case of
Party
page,
Malot 94, 95. Accordingly, the impugned orders notice channel in the case of repetition, that is NID data so are set as a request. Last record, 52. All NID issued by the MSC has been set as a.
this court in the above case has held that the general council or the village council of the MAC has got no authority to settle any fishery or even natural water bodies as exemplified in the notification dated 7/3/2017 issued by issued in the name of the governor by the principal secretary to the government of the Assam Fishery Department. And consequently, they cannot initiate any process for settlement of the fisheries or water bodies. Or settle the same. Pusta. Then you read in page 88, the order dated. No, the notification dated 7/3/2017 is reproduced here in bill. Page 88, 89. Next one. In view of the settled position of law that the MSC does not have any right to settle any fishery or water body within the state of Assam, the settlement of the Mori Disoi Senge Listitu Min Mahal in favor of the respondent number 9 by the MAC is illegal and the same is accordingly set aside. The writ petition is accordingly disposed of. Next. Yes. Mr. G. Pokalal, counsel for the response. Granted 3 weeks time to file affidavit with regard to the vehicle hire charges payable to the petition. Next.
Lord,
Yes.
this petition, the petitioner is challenging the change of the eligibility criteria after the tender process has already started.
After the tender process.
And the petitioner
No,
has
was it after the last date of submission of the tender?
Before the last date of submission, but the petitioner had already participated.
Petitioner participated does not mean that. Petitioner had submitted his bid.
He has submitted his bid.
But then prior to the bid opening, it has been changed. Prior to the last date of.
Prior to the last date.
So we'll have to see.
Yes, once the game has commenced.
I do not know.
No.
I do not know whether you have got a case. We'll have to see. Yeah, I know you are relying on Tej Prakash case. Tej Prakash. Now whether that Tej Prakash case will apply to your case, I don't know. Right. The case of the petitioner is that the petitioner had submitted his tender as he was eligible to participate in the tender as per the NIT. Yes. Mustafa, however, prior to the last date of submission of the tender, the eligibility criteria for participation of tenderers was changed, which barred the petitioner, which disqualified the petitioner from participating.
Doesn't fulfill, but even
Which disqualified the petitioner from participating in the tender. He submits that the rules of the game cannot be changed after the game has been played. Mustafa, however, in the present case, the rules, the eligibility criteria appears to have been changed prior to the last date of submission of the tender. And as such, it would have to be, and as such, a consideration is required as to whether the petitioner's case would fit into the law laid down by the Constitution Bench of the Supreme Court in Tej Prakash. What is the citation?
I'm not carrying it today.
Tej Prakash, huh? Tej Prakash.
I'll just give this. I was
No,
also
no.
relying on Dutta Associates to show that once the criteria have been.
No, this is different. This is different. This is when, you see, I can understand if the last date of tender is closed.
7 days prior to.
Prior to opening.
And when he got to know that the rules are changed, immediately find that.
No. Yes. As soon as I came to know that it has been changed.
So on the date it was changed, he established.
Before the date, he knew it.
Before the date, he knew his
He knew it
smart
and
guy.
immediately he changed.
So we have to
Not
see
you
now.
fixed it on agencies that supply of tax and mention to the student.
Leave the matter on.
Second of the.
Second.
Interim order.
There is an interim order.
Here tomorrow.
No, tomorrow is one.
Tomorrow. Second is the after. Tomorrow is one. Huh?
On second one, there is agency of tax, supply of
Okay,
tax.
leave the matter the after.
My interim order will be.
Interim order to continue till then.
Okay.
Okay, I'll just give the citation right.
What is 41?
Auction matter, my lord.
Oh, yeah.
The successful done with the lifted material, my lord.
Huh?
My lord paid the entire amount, my lord. And my lord to also buy on paper, my lord, yes, my lord taken over the
Lifted.
possession, but did not take the physical position. Then, my lord, after giving them notice, my lord, ample opportunity, my lord, we, my lord, retendered it, my lord, to MSTC, my lord. My lord, BSNL cannot, my lord, float tender, my lord, auction material, my lord. It has to be through MSTC, my lord. So, my lord, we have again requested MSTC, my lord, they have floated the tender, my lord. He again participated, my lord. He paid the security, he became the L1 bidder. He paid the security deposit, my lord. Then we issued the letter, my lord, to pay the remaining amount. And
He's not paid.
My lord. That is the case. my lord.
Yes.
Lordship, in the first NIT, Your Lordship, I was declared the successful bidder. Accordingly, I went to collect the materials. But when I went there was a big difference in the quantities of materials that were being given. And
In
that
the
was
quantity or in the weight?
in the weight, that is what quantity means. So initially, they said that 176 number is weight 52 kilo. While I went and I tried to take it out, I weighed to the machine. I found that it was not 52 but 32. So I made a representation.
When was this?
It was during the
Which
early,
year?
it was in 2020, 21, 22.
Then what did you do?
Then I made I write a letter that you kindly provide me the full, or you may deduct the money of the amount that is.
And now in the present NIT that has been issued,
Lordship.
is the weight the same as the earlier weight?
Now they are not allowing me to go and wait because they have said that I earlier take the full materials. Now what I am on, Your Lordship, in respect to the first auction, that has now been terminated by issuing of the second tender. As per the earlier tender, there was a provision that if within the stipulated time, the person who has got it or the highest bidder does not take it, his earnest money should be forfeited. So that can be done, that can be forfeited. The remaining amount I am entitled to kept. That amount, if they readjust, I would take it, whatever materials available.
My lord, from 21, my lord, it was lying there.
Acha, the demerit charges over.
My lord, they were not demurrage, sir. My lord, now who will, my lord, take that?
I will take subject.
My lord, he'll take the material, my lord, we will, my lord, allow him.
Yes.
My lord, as per the first option,
You want-
my lord, but only the demurrage he has to pay, my lord. There is a condition to that effect, my lord. And my lord, the condition is that, my lord, he'll have to lift it by at least within 60 days, my lord. Then, my lord, we
Yes.
can return that, my lord.
No, if demurrage is there, your lordship, demurrage is for 90 days. Thereafter, actually the auction or the contract stands cancelled by operation of law. If they say about demurrage for 90 days, it may be there. Some 1% or 2%.
My lord, the demurrage is for 30 days.
Instead of going into
And, my
all
lord,
these,
the
your
entire
lordship,
So how much demurrage do you want?
My lord, we do not want demurrage, my lord. We would like, my lord, since he has paid, my lord, he can lift the matter.
Yes,
My lord, now, my lord, if, my lord, for last 5
Right.
years, it is
Can
like
you
this,
lift?
my lord, in open air.
you
my lord.
lift it?
Who will, my lord, to take that, my lord?
What? What?
lifted means we have already given whatever.
Correct, you have given. So they only want you to take. This is like Peter Sellers, you know? Take it, then go.
And
That's
lots-
all. So are you going to take it?
Lordship, can it Monday I'm taking step now?
Okay. You take instructions.
Yes, yes.
Because that's the only thing now.
That's the only thing.
And then the security deposit you can give back. Or what? No, that will go.
That will go, my lord, because, my lord, the MSTC has conducted.
MSTC.
MSTC has done.
So demurrage to you won't charge.
My lord, Lordship may direct that you do not charge, my lord. I cannot say from myself, my lord.
You also obtain instruction
Well, I-
as to how much demurrage will you charge.
My lord,
Okay.
my lord,
And you also obtain instructions as to how much demurrage you can pay.
my lord.
And whether you will pay. We'll see, then we'll see. At least I want to have an idea of your client's mindset. Okay.
Next.
Here's the party list the matter on?
Next Friday.
No, not this Friday. Tuesday.
Oblige us.
Yes.
This involves payment from various divisions. One division we have cleared by us.
So what to do?
Lordship will fix it some of the few days. We are processing the payment. One division has been cleared, madam.
Okay. Mr. Dio submits that respondents are processing the payments accordingly. Leave this matter after a week. Yes, we have not taken steps on R7.
Lordship, this is not required, my lord. This respondent number 7 may be struck down, my lord. Earlier, my lord, at the time of filing this writ petition, I was working under the respondent.
Now, what is to be done? What is to be done?
My lord, subsequent
Now-
to the filing of the writ petition, the petitioner has been granted the enhanced remuneration.
End of the matter.
That was not given, my lord.
Yes, let him see, let him see. Yes. Heard, Mr.
HR Ashton, my lord.
Astal, counsel for the petitioner, and Mr.
And Sharma,
N. Sharma,
for 2, 3, and 5.
for response number 2, 3, and 5. He submits that subsequent to the filing of the writ petition, the petitioner has been given the enhanced wages slash pay by office order dated 14/12/2023. Pusta. In view of the above, the writ petition stands closed. Pusta.
Lordship, as per this office order, my lord, salary may be given. my lord. Salary was not given as per this office order. my lord.
Pusta. It is made clear, as per the office order, huh? The office order is made a part of the report and marked as an extra. It is needless to add that the enhanced wages will have to be paid to the petitioner in terms of the office order dated 14/12/20. That's all. From the date of application of from the date of coming into force of the office order. Correct? Yes, next. Next. 33, Infructuous.
Yes, I think you say Infructuous.
Yes,
Lordship,
Mr.
because
Khan.
a new tender has been issued and new settlement has
This
been
is
done. Lordship.
Infructuous.
Lordship, this matter is only regarding the final installment, Lordship. There's a- Lordship, we have made a prayer, Lordship.
You see, he has settled with that market, okay? For the period from 23 to 24, January 24. Now with regard to the loss.
The loss, Lordship.
Loss.
There's a A subsequent order has been passed by the municipal
So
court.
this loss, how are we going to calculate?
Yes,
Whether you have
Lordship.
caused
They
the loss,
may
that is
file
a question of fact.
Because we were only able to run the market properly for only 1 month, Lordship. Subsequently, our road was went through the market. As a result,
Have you filed any representation to the company?
yes, no, Lordship, the only
And this is
representation
the-
that's closed. That has been disposed.
Have been rejected?
Yes.
Lordship, now we had filed an IA by which Lordship had allowed us to challenge that order by which the representation was disposed of along with the order by which they had directed us to pay the final case money.
Look at your prayer.
Lordship.
Look at your prayer.
Lordship, the first 2 prayers are not applicable now. However, the third prayer, Lordship.
That effect, no order has been passed, Lordship, regarding modification of the prayer.
Then Lordship, I may be allowed some time, Lordship. I have to take instructions.
So what?
Regarding that final installment, Lordship. Because
They have,
if we may either have to amend this petition or we have to file a fresh.
You withdraw with liberty to file a fresh.
yes, Lord.
Mr.
BS Deca, Lordship.
B.S. Deca.
BS Deca.
Learned counsel for the petitioner, please that he may be able to the raise petition with liberty to file a fresh. The same not objected to by Mr. M.D.
M.
M. Bhattacharya. Learned counsel for the respondent. Raise petition is according to petition has withdrawn, come up with liberty of statement. Next.
Deeply applied.
Lordship.
Yes.
1 week time may be granted to file the affidavit, Lordship. It is almost ready. We just need signature of
You all have been adjourning this.
responding to the response. They will not come with the personal difficulties.
Possession of 2 stalls, right? The respondent number 5 is given the last chance to file affidavit within a week. The matter pertains to the dispute with regard to possession of 2 stalls by 2 brothers. Is the matter after a week.
35. My lord, here is this matter just.
35 has to be dismissed. No, sorry, no, 35.
35, man.
35 is,
Lord,
yes,
this
time.
morning I have received updated instruction. I'll file an.
Okay,
affidavit. Can it be
Mr.
on
N.
8?
Upadhyay,
Due permanent.
due permanent is granted.
My
2
lord,
weeks,
time, Lord.
huh?
2 weeks.
2 weeks time to file
My lord,
affidavit as he has received thorough comment.
A
This
date
is
may
the
be fixed,
matter.
my lord. A date.
Huh?
A date may be
Give a date.
Alright.
36.
36 has to be dismissed. 36 has to be dismissed because your prayer cannot be granted. You have got to amend the earlier the disposal of writ petition. You please see your prayer.
Lordship, I will be allowed to withdraw this.
You withdraw. It is not because there is no typographical
Yes,
error made. It is as per your writ
Yes,
petition.
Lordship.
Mr.
Yes, sir.
S. Ali.
Yes, Lordship.
Learned counsel for the applicants praise that he may be allowed to withdraw the application.
And actually,
Huh?
fresh file, Lordship.
Huh?
To file a fresh IA, Lordship.
And file a fresh application.
Yes, Lordship.
And file a proper application.
Yes, Lord.
As per Mr.
Yeah, on
appears on behalf of
SR Rabha.
S.R. Rama, counsel for the
BTC.
BTC.
Obliged.
The press allowed the petition, the application dismissed as withdrawn with liberty of speech.
Obliged.
Yes.
Again, my lord, today I have a local number for the respondent process.
Mr.
D. Gogol.
D. Gogoi submits that he has filed Vakalatnama on behalf of respondent number 6.
Yes, sir.
He is accordingly granted
2 weeks time.
2 weeks time to file affidavit. Mr.
And to some guys, can come back.
Mr. N. Goswami, excise for the excise department is also granted 2 weeks time to file
Lordship,
affidavit.
there's an interim order.
This is the matter of 2 weeks interim order.